Okay, good afternoon, everyone. I'll now call today's Special Council Committee of the Whole meeting to order. I would like to begin by recognizing that we are holding this meeting on the lands of the Sooke Nation. And I will turn to item 3, Council looking for approval of today's agenda. Moved by Councillor St. Pierre. All those in favor, please. None opposed. That's carried unanimously. And that'll take us into item 4, reports for the development procedures bylaw. I'll turn this over to staff, please.
Yeah, thank you. Yeah, so as part of the Development Approval Process Review Project, or DAPR, the district has been working with Urban Systems to improve its procedures to make them more clear and transparent, take advantage of opportunities to streamline development approvals where appropriate, and to bring them up to date with industry best practices and legislation. The DAPR project has included the development of an update to internal procedures manuals, application forms, external guides, templates, and bylaws. As part of this work and the focus of today's agenda item, staff are seeking direction from regarding the draft procedures bylaw, prior to staff presenting the bylaw to council for readings. More specifically, staff are requesting direction on the items listed in the recommended motion of the report, including proposed changes to notice of application signage, public information meetings, and delegation of authority as it relates to development permits, minor development variance permits, and residential strata conversions. To present background on this work and facilitate the discussion on these items, the project consultant will be joining us virtually. They're in-house right now. With that, I'll turn it over to Nancy Henderson, Brittany Tuttle, and Talia Mamura of Urban Systems.
Thanks, Jaden. Good afternoon, Mayor and Council. We are happy to be here today to be presenting on the Development Approvals Process Review Program that we've been working with staff on for a number of months now. We are nearing the end of this program, which is very exciting, and we're looking forward to seeking some feedback from you today. So thanks, Jane, for the introduction. I think that you have met us and seen us all before a few times now, but just as a reminder, my name is Brittany Tuttle, and I'm joined by Nancy and Talia with me online here today. And we'll each be taking some turns throughout the presentation or today's meeting to chat with you about the procedures bylaw. So before we get into the presentation today, I'll give you a quick overview of what it is that we will be discussing with you this afternoon. So first of all, we will be doing a recap for you on what a development procedures bylaw is and why it's so important for improving development processes in the district. Then we'll be talking to you about what the current practice is with your procedures bylaw right now, providing you with a recap of some past decisions that the Committee of the Whole made at our last meeting in December, and how we have been integrating that into the new draft procedures bylaw that was circulated to you in your agenda package for today. And included in there are some recommended amendments and motions, as Jaden mentioned, and we'll be walking you through each of those recommendations and how they relate to what's currently in your existing procedures bylaw. And that will be the bulk of the discussion and the presentation today, as we'll be seeking direction from you on how to move forward with those items. And then we will wrap up letting you know what our next steps are as it relates to this project and the procedures bylaw moving forward. Okay, so we will start off with the first item, which is what is a procedures bylaw? So a procedures bylaw, as defined on this slide, is a bylaw that outlines procedures for processing development applications within a local government. And it incorporates a number of regulations that stem from a variety of different legislative powers in the Local Government Act. So as well as in the community charter as well. So for example, shown on the slide here is the powers given to local governments under Section 486 of the Local Government Act. And I'm going to show you on the next slide some of the powers that are given under Section 487. But these powers relate to requesting development approval information If your official community plan, for example, outlines circumstances when a local government may request information in terms of what types of information may be required as part of a development application submission, or if certain areas are defined in the OCP as well. And so this section, specifically section 486, requires procedures to be established for when approval information is required, and this can be done via bylaw such as a procedures bylaw. And so moving on to section 487, this section of the Local Government Act goes on further to indicate that a local government may require development approval information for different types of applications via bylaw, which could be done through your procedures bylaw. And the LGA also indicates that any required approval information must be provided at the applicant's expense in accordance with any procedures established by the local government through the bylaw. So this grants local governments some flexibility in terms of defining procedures in their procedures bylaw that best suit the context of the local government, as well as also establishing appropriate fees in terms of how you may want to go about reviewing and processing different types of development applications. And so you can establish fees for associated with the review and processing of those applications in a fees bylaw or within the procedures bylaw itself, but usually best practice is to have those in a separate fees bylaw. Okay, so in terms of thinking about what actually is included within a procedures bylaw, there's a number of best practices here, which are shown on this list on the slide in terms of what goes in these bylaws. So in addition to the actual processes associated with all the different types of development applications, there you can also include information about what types of information may be requested as part of the review of an application. And these are usually documents that are required by qualified professionals. You can also outline how an application may be referred. You can talk about any types of public engagement that the local government may require outside of a public hearing, which is prescribed by legislation. You can discuss when security might be required, for example, and any rate that may be associated with that. You can talk about things related to liquor licensing and cannabis, which are also have their own separate legislative processes, and discussing how those could be integrated at the local government level. You can also discuss how the public may be notified of an application, so requirements related to signage or mailing out notices. You can also outline procedures for what happens to an application if it needs to be amended after it was submitted, or perhaps if it needs to be extended in terms of the time frame, or if something happened and it has lapsed, then how staff would go about handling those situations. You can also discuss what approval authorities may be delegated to staff or council, also as per the authorities granted to you by the Local Government Act. And one thing that I should note here about procedures bylaws is the details of how you actually go about processing an application are not always explicitly defined in the procedures bylaw. A lot of some of those details are further defined through internal manuals that are used by staff to help guide them through the development processes associated with each application type. And those are something that we have been working on with staff as part of this process as well, to help more clearly lay out the processes associated with reviewing development applications. Okay, so something else that we have been considering as part of this review is actually consolidating some procedures that were outlined in other bylaws that the district currently has. And I'm going to show you a list on the next slide of what those look like. We've also been thinking about development approval information, so things that staff and council may want to ask for from a applicant, as well as how we could more better streamline the approvals of applications through thinking about delegated authority and what application types might be best delegated to staff rather than council to speed up the process. So here is a list of other bylaws that we have been reviewing as part of this project. And many of them can be consolidated into the procedures bylaw. So as part of this project, we'll be recommending to council that the procedures bylaw replaces the existing procedures bylaw number 490, which was adopted in 2011, as well as the development permit delegation bylaw, the development application procedures policy, the liquor license application procedure policy, the agricultural land reserve application procedure policy, and this residential strata title conversion policy, because all of the aspects or the key components of these bylaws and policies have been integrated into our new procedures bylaw. The floodplain regulations bylaw would also need to be amended, as any procedural items that are currently outlined in that bylaw, we also propose to integrate them into the procedures bylaw as well. So if this new bylaw is adopted in the future, this floodplain regulations bylaw would need to be amended to remove those items that have been integrated into the procedures bylaw. Okay, so moving on to our next agenda item as it relates to the amendments to the bylaw themselves. As I mentioned before, in this portion of the presentation, we're going to discuss with you what your current process is for different aspects of your procedures bylaw and what it is that we are proposing or recommending to the committee for consideration. And so the first item that we're going to be discussing today is public hearings. I know that we have talked to you about public hearings before, as well when we were present a month ago to discuss the new small-scale multi-unit housing legislation. There was a little bit of discussion about the new public hearing requirements under Bill 44, which is the new legislation, but we're going to provide a recap for that today, just so that it's fresh in everyone's heads as we go into this part of the discussion. So as you are aware, under Bill 26, which has recently been superseded by Bill 44, at the end of 2023, the Local Government Act no longer requires public hearings for applications that are in alignment with the OCP. However, despite those public hearing requirements being waived, you still need to provide notice of the bylaw being given first reading. And so under Bill 44, the public hearing prohibition has been sort of further extended in terms of, or I should say broadened, to now prohibit public hearings for zoning amendments, zoning bylaws and amendments, where the application or amendment is consistent with the official community plan, so that part remains the same, but also for bylaw amendments that are to permit residential development, where, let's say, a mixed-use development, for example, proposes at least 50% of the gross floor area as residential, and for amendments that propose to provide small-scale multi-unit housing. And so small-scale multi-unit housing is defined by the province as a form of housing that could be providing potentially up to 6 units of housing, but in the district's case, this would probably be up to 4 units of housing because of your requirements under the new small-scale multi-unit housing legislation. So this could be something like a duplex or a triplex, a fourplex, any combination of what is more commonly referred to as infill type housing. But again, despite the public hearing not being required, you still need to give notice under the Local Government Act prior to first reading of the amendments.
We just pause there for a question, Councillor St. Pierre.
Absolutely.
Go back to the previous slide, please.
Yes.
And this is just for clarification because I doubt this is what it really means. Prohibited for, it has to be consistent with the OCP and it's to permit residential, but it still has to be consistent with the OCP, correct? In order to,
Yes,
okay, so that is absolute. Okay, the way it
that's
was
correct.
sounded like if it was for residential development, then regardless of the OCP, we couldn't have a public hearing. And I just wanted to make sure that's what it looks like, but that can't be right. So thank you.
Councillor Bateman.
Could you go back one more slide? No longer requires default requirement, but that does give this council an option to with, I see the shaking head there. No. So we do not, unless the director of planning recommends that it's in the public interest.
Yeah, I'll speak to this. This is Bill 26, which has been superseded. So the language changed in the LGA from not required or strongly not required public hearing. So it could be waived to Bill 44, which is now prohibited under those conditions.
Thanks, Jaden.
Okay, everyone's good? Okay, but we still have to advertise that we're having a public hearing, even though the public hearing is prohibited.
You have to give notice that there will be first reading of the bylaw amendment.
So we
And
give
that's-
notice that we're having a public hearing, but we're notice that we're giving the bylaw first reading, but the public hearing is prohibited.
That's
Yeah.
correct.
Seems. Okay, never mind.
A big change. Okay, we'll just carry on. We have one more slide on this topic. And so this is just to speak to the fact that, yes, there will be reduced opportunities, it seems, to allow for public engagement as it relates to development applications being brought forth. However, the expectation from the province is that now public engagement is going to occur earlier on in the process. So it's not that public engagement opportunities are completely eliminated. It's that the province is now encouraging local governments to have that comprehensive engagement process earlier on when you're updating your OCPs, particularly for housing, because the province is now requiring that local governments identify where they would like to put new residential development to meet the needs identified under their housing needs reports in their official community plans. And then it's intended that your zoning will be in alignment with your OCP. So then any new development that is being proposed will already be in line with those two documents, and the community will have had their say on what that type of development could look like. So this is the intent of the province to help streamline providing more homes faster, is by having the engagement upfront. However, despite that being said, local governments could still encourage or require meetings to be hosted by the applicant or the local government themselves, such as public information meetings. And those could be an opportunity to provide the community with more feedback or information about a development application that's being brought forth. And so that is something that we have discussed with yourselves, Mayor and Council, previously. And it's something that we'll be talking with you more about today, is those public information meetings and what those could look like. Another piece of information that a local government could provide to the public is a notice of application sign. So you already have these signs as well required for certain types of applications under your existing procedures bylaw. And so we're going to be talking about those a little bit more today as well. But that is another opportunity to help notify the community beyond that required notice of what is going on in terms of new development applications. So maybe I'll pause here before we jump into the next topic, just to see if there's any other questions or comments.
And that's fine. Just procedurally, I'm gonna ask staff here, like within our, like just looking at how we're gonna function today, getting through this material. There's a suite of recommendations that are coming up. So is it the case where we address the recommendations with the section in the presentation, or is it better to hear the whole presentation and then come back and go through these one by one?
Through the mayor to council. Council can do either. I do have the recommendations in front of you and on the slide deck for today's meeting. In the event that we were to finish the presentation and then consider the recommendations one by one, or if council finds it more suitable to address these as they come up throughout the presentation, and give staff direction on what the motions should look like. That is something I could capture as well as you discuss it through the presentation, and then we can look at each motion at the end. Sorry if that was confusing. We could do either way, whatever council finds most suitable for their decision making, but I have provided the resolutions in front of you, and it is on our slide deck if we did want to wait.
Okay, so council, I was thinking we would go through the presentation and then come back. Is that fine, or do you want to do them as we go along? Presentation and then revisit it? Okay. Okay, there was a few questions. I'll go to Beddoes, then Bateman, then St. Pierre.
Yeah, I guess the flaw I see, basically putting notice for the public to pay attention when we're building the OCP. And I guess my question is, that's not always done, and not just with the public, but with some of the building community as well. Really didn't take a lot of notice until it was tabled. And if there's something wrong in the OCP, will staff alert us to it, to possibly a change? Because there's going to be mistakes in it. There's no ifs, ands, or buts. That's going to happen in the OCP. And my concern is if it's in the OCP and you have to make the decision to go ahead with this application, what avenues do we have to change that? Maybe the OCP is wrong. I don't know, does that make sense? Or I guess what my concern is, from my experience, when we're doing an OCP, and I guess we're going to be redoing the one that we have in the draft, some things could slip through. How do we change that? If it came to here for a public hearing, we'd have a possibility of changing it. But now staff is going to go by the Bible of the OCP, and the OCPs aren't perfect. So, I mean, what's the mechanism for that?
Yeah, so the OCP could be updated and reviewed every 5 years. So with the new legislation in place, that's what we'd be doing, is a review every 5 years. If there is some inconsistencies or whatnot reflected in the OCP after it's adopted, it's possible to, of course, amend the OCP at any time at the discretion of council. If that answers your question.
Yeah, I guess it does. I guess I'm so unhappy with this whole procedure, not the procedure, but this whole legislation, that it, we have all sorts of checks and balances, and I guess the last check and balance is us at council here, and that's what we're elected to do. And we may not see some of these mistakes that may go through. So anyway, your answer is fine. I don't have a problem with it.
Okay, Bateman, then St. Pierre.
Yeah, I'm just curious about public input today. How will you handle that?
Probably after the presentation.
One opportunity after the presentation.
Yeah, because unless there's something, we only have 2 members of the public. So perhaps if either of you indicate there is something in a certain section that you'd like to comment on, then just me raise a hand and I can acknowledge you within the presentation to get it answered, or after the presentation, we can still have it answered. So there'll be an opportunity for that today. I'll go to council members first. Councillor St. Pierre.
Councilor Bateman just took care of it. Thanks.
Okay, Councillor Pearson.
Yeah, yeah, thank you through the chair. So following on Councillor Beto's comments there, the current practice, and I'm just kind of thinking about how we're gonna how we're gonna navigate the new waters. So our current practice is that an application comes forward with an opportunity to vote on the OCP, like amend the OCP. That's been sort of past practice. So we say, okay, and by the way, this development approval is now approved and you've got to go into the background. So without the lack of hearing, without the lack of public input, it feels like we're missing a step. It's like, and I don't know quite how to articulate this, is that our ears and eyes on the ground for developments, for council, us sitting here, is in this chamber. Quite often, you know, it's an application that comes forward, a variance that comes forward, and it has a series of recommendations in there. Now, the province has taken that particular piece away from us at the front end. And I'm kind of worried about the OCP being a roadblock as opposed to, does the development make sense? Because you said, you know, we have to wait 5 years. So can the applicant, where does the applicant have an opportunity to say, I would like to get in front of council and see if I can have the OCP amended? Is that going to be a process? Because in the past, it was a staff recommendation.
Just
Oh.
Councillor Pearson, my understanding with the legislation, and I'll ask staff if I'm wrong here, is that if an application requires an OCP amendment, then it does have to go through the public hearing process and come to council, and there can be an application to amend the OCP. And that requires public notice and public input because they're amending the OCP. These ones here where we're shut out is solely applications in line with the OCP. That's correct, right? So at any
That's correct.
time prior to 5 years, an application could ask for council to amend the OCP on that particular property.
And also in stream, so there'd be potential to have text amendments to the OCP done as well in between those 5-year periods. But there'd be a comprehensive review every 5 years of the OCP.
Yeah. And I'm following that bouncing ball. I'm wondering about sewer specified area as an example. I mean, and I'm going to come up with, so does an applicant at the very front end have the opportunity to make an OCP amendment? Not necessarily to support the project in general.
Yeah, through the chair, I guess their opportunity to be through the engagement process of the official community plan. So that's when we take in public feedback, present that to council, and it should craft the way that the OCPs are drafted and then go through readings. At the front end.
And so that's giving me some more cause for concern, following along with what Councillor Betos just said, is that if the OCP is wrong, or we've got it wrong as a community, then that process looks a little more cumbersome. So thank you.
Over to Ms. Moog.
Sorry, thank you. And through your worship, just to extend on the slide that's before you at the moment and the focus on that might help alleviate some of the concerns I'm hearing from council. I think that this is the opportunity that the public information sessions may present, is that very specific early connection between the applicant, the developer, and the community really early on in the process. So I think as the presentation continues and we hear more about the public information session, that might be the opportunity that council is looking for, and I think it might alleviate some of your concerns. So I think if it may be valuable to hold further aspects of this conversation to see when that comes forward, if Urban is able to provide more information and direction specific to the previous council's discussion on the public information sessions, that might be helpful.
Okay, Councillor St. Pierre again.
I actually have a question through your worship for Ms. Moog. I understand there's going to be a communication policy or document coming forward. I know one of the things that does come forward is a fair amount of correspondence around any one of these items. at this point in time, it's not necessarily always easily attached to a particular file. I think there's a plan to do something like that within the communication strategy. Is this a separate policy that we're waiting for before the procedures, or is it a part of the procedures, or how's that going, how are the two documents going to interact? How are the two pieces going to work together, I guess, what I'm asking.
So through your worship, through the work that we've done early on in the process where we identified the need for a public participation policy. So that's under development, and in that conversation, staff have in taking that away from council through council's direction, we've really teased out the correspondence policy separate from the public participation. I'm looking to bring that forward to a committee of the whole on, I believe it's May 21st is the next available committee of the whole for us to workshop that. I think it's fair though that we can handle those separately. The correspondence policy will address and help provide more succinct direction on receiving related correspondence to development files it'll be handled separately, and we've identified that problem, and hopefully the policy as it's written will solve that. But that's certainly something we're looking forward to workshopping with council at the next committee of the whole. So I think that will help with this process as well.
Further to that question, I'm curious if we have phone calls, correspondence, other means of communication. We have data from the public. It's certainly possible to include that stuff somehow in our deliberations. Even if we don't actually have a public hearing, if information is brought forward, that can all be part of our package. We don't have any strictures from the province on that account, do we? There's no restrictions on that.
It hasn't been tested yet, so I don't have necessarily a clear answer because this is unprecedented. We're in sort of uncharted waters at this stage. We've received some forms of legal guidance and interpretation. Again, there's no precedent. There's been no case law set on this. What does a pseudo public hearing officially look like? Is that the written record and how it's applied to council? Are there alternative ways of handling that? I think within our correspondence policy specific to these files and something in operating practices we have been navigating in Sooke is that before a file is before you, and council have seen these correspondences, we provide the 14-step, et cetera, rezoning where it is in the process, and essentially have those correspondences be held off to come forward until they're given the whole context of the actual file. So managing correspondence that comes to us too prematurely before we actually have the specifics worked out between an applicant and staff is one of the problems that we're looking to solve. And I think that's a tool to do that. How it gets delivered to council, we can certainly capture that in a different way, but to specifically answer your question, I wish I was more confident in answering you. But this is part of the changing waters that we're navigating, so.
Okay, just further to that, I think Councillor Pearson was pointing out that we often get information from the public in terms of where there might be gaps in our understanding. There's also a lot of potentially emotion and volatility in the room, and I think that the province is hoping to reduce pressure on councils and move applications through, but at the same time, we don't want to lose that information that we can get from the public, so.
Mr. Blewett?
Just for clarification, it seems there may be some misunderstanding around the OCP amendments. A member of the public or an applicant can make an application to change that at any given time. So the 5-year timeline is just to ensure that local governments actually are revisiting their OCP regularly. So if a member of the public wanted to make an application, they can certainly do that at any given time. And then if council found something in the OCP that wasn't working, you can direct staff to investigate and prepare a report and bring that back. As well, staff can, recognize that there are things that are not working, such as the TMP. There's a lot of variances recently. So Mr. Carter is moving forward with amendments to the TMP potentially with that regard. And that was driven from the number of variants, staff bringing that to council saying, hey, we see a problem, and asking direction from council. So certainly at any given time, to summarize all that, an OCP amendment can take place.
I understand a member of the public wishes to address council. Can you please come forward and turn on the microphone and introduce yourself?
And are there time limits on public input at this stage?
Well, a couple of minutes, because we don't want to be here all day and night, but.
Yeah, or I'll come back a bunch of different times. Yeah, of course. You guys are on the
You
right
need to
track.
introduce yourself.
Herb Haldane, 3118C Otter Point Road. with the Sooke Builders Association, but I'm also a builder in Sooke. Some of the stuff you're talking about, and Kevin and Al bridged on it a little bit. Even the development community needs council to be involved in the applications that are going through and going forward. If you guys don't know what's going on, it makes it impossible for us to either have concerns, complaints, misunderstandings. And right now, and I don't know how to put it, I don't mean it in the wrong way, or I don't know how it's going to come up, but during COVID, you changed a lot of bylaws, procedure bylaws, building bylaws, bylaw 404. You just made mention to it, there's some changes coming forward because you got so many variances that are happening. Well, this is happening because the bylaw is not working. So if you give staff all this delegated authority to use these bylaws, that was no public input during the COVID times, of course. So a lot of the stuff was staff driven because at that time, they want to try and get things done. So they think they're doing what the public and what council wants. But in the end, it misses the input from the public and from the builders community, what works and what doesn't work. And there's a lot of stuff being implemented that doesn't work. We came forward to you guys about 1.5 years or 2 years ago, if you remember, and we asked about the boulevards being done in rock. And
There's a point of order here.
Yeah, Mr. Haldane, through you to Mr. Haldane, thank you for this, but I think this is the sort of big picture summary statements that need to follow the presentation. And because otherwise I'm getting fuzzy already. It's so if through you, I would suggest that public comment be held until we reach the end of this presentation.
Or Mr. Haldane, if you can contain it to what we've heard in the presentation so far, then that would help. So, because we're going through this section by section.
Yeah.
And we want to hear from anyone present on the various information we've received before we make a decision. So if you have anything to comment on what we've heard so far, which is basically the status of where we're at and here we are, and the public engagement pieces to date, that would be helpful.
So
and then otherwise I'll invite you back at the end.
Sure. So if the government is going to get rid of public hearings because they think that's going to make things go faster, that's a piece of public engagement that's lost. So what I'm saying then is don't give up what little you have left, which is the delegated authority. So keep us coming back, keep us seeing you. I'm telling you from the Builders Association and as a builder, as somebody who helps people do subdivisions and rezones and stuff in Sooke, that I want that part to maintain, because I don't think it goes any faster if we lose it all towards the staff, because staff's already empowered through lots of these bylaws, which is what I'm trying to tell you, for it to work in their favor that way. So I would like to be in front of you guys more often. That's what I'm saying. I have no issue with it. Time is not of the essence for me when it comes to you guys understanding what we're trying to accomplish or do. Then we're not going for these variances that you guys have had come in front of you quite a bit in the last little while.
Okay. But I will just correct a bit of a narrative in that, yes, COVID had us recessed for a while until new legislation came about for council to continue, and council at that time could have pressed pause on everything, but instead used that time to do a lot of housekeeping and a lot of cleanup, and public participation was available, although it was in a virtual format.
Mm-hmm.
And then we did our best to comply with restrictions to obtain as much public input as we could, in which case we did, because participation coming into this chambers is often a barrier for many, whereas the online format actually enabled us to engage with residents for the first time ever. So I can appreciate that the Sooke Builders Association, whom you represent now, may have a different take on this. We are still here for all of the people in our community, and they want to see development done differently. And that's the balancing act of where we are today. So I don't want to enter into a debate with you on this. I'm just correcting that we didn't shut out the public. We could have just shut down all construction and development fully, but instead we found a way to work through that, knowing that this was a big part of the process. I see that another member is disagreeing with me, but my point there is that we continued to get on with the business of the day in the best that we could, given the restrictions we had to deal with. And that was a challenging time for everyone in this room, yourselves included.
Yeah, I know how difficult it was. And that's why we came forward a few times during the process just after COVID. And my example there was you guys had passed with a motion from the floor, voted on it, and it's never been implemented into the bylaw 404, and it's never been.
But
pushed
that's
forward.
why we're
Yeah.
getting to this now. In the previous slide where it's consolidating pieces and making clarity so that there's one overarching document, not 5 or 7 in all different places. We're trying to streamline the process because our option is to streamline it, make it more clear and consistent, or to just leave it as it is today. But there's an appetite around this room to streamline it, to be more considerate, more concise in terms of what we're for, so that the approval isn't one barrier after another. Okay,
Yeah.
we'll leave it at that for now. Thank you, Councillor St. Pierre, and then I'd like to move on.
Okay, I was hoping to move on to delegated authority, but I had a comment on delegated authority. And that's my understanding of delegated authority is that there's a misunderstanding here. Delegated authority allows staff to move forward and basically ratify decisions that are relatively minor. And if an applicant wants to bring it forward to council, that option is still there. So the only time an applicant might want to come to council is they're not getting what they want from staff. But meanwhile, it'll speed things up for everybody because basically the applicant get a quick turnaround, they get their thing accepted. They're not going to want to see council then because we're just slowing them down. We're there as the backup measure and we're still there. So I think there's just a misunderstanding and a fear around delegated authority that doesn't need to be there.
Okay, well, we haven't gotten to that section yet in the report. Yes, so let's, we'll get through that and then we will carry on, but council of the day will determine what they are willing to delegate, if any. Okay, moving along, please.
All right, so thank you, Mayor and Council. I am going to be talking a little bit more about the public engagement strategies essentially that are available, and that's through notice of application and through public information meetings. So the first is notice of application. These signs are used to notify the public of an upcoming development. And the current development procedures bylaw signs are required to be posted on the property that's subject to an application to amend the official community plan bylaw or the zoning bylaw. With the development application forms, though, they currently request signs for more than just the OCP and zoning amendment applications. The current development procedures bylaw outlines that a sign must be posted within 24 hours of the application being filed. Now, 24 hours was used when the applicant would drop off the application, they would give a deposit and carry out with them a sort of one-size-fits-all type sign and then receive the deposit when the sign was returned. And so this process in the bylaw is outdated and it's not what's done in practice. In practice, and what is often recommended is that the onus is on the applicants to print and post these signs. So staff will make up the digital file of the notice sign, provide it to the applicant with detailed instructions and a guide for how to print, install, maintain, and remove the signs. And then the applicant is responsible for printing and posting the sign. So the following motion was discussed and carried at the last committee of the whole meeting in December that we spoke to you about. So that the development procedures bylaw essentially maintain the requirement for notice of application signs for OCP and zoning bylaw amendments, and that these notice of application signs be required for zoning bylaw amendments for applications even where public hearings are not required. And we confirmed that notice of application signs are not required for temporary use permits or variances to development permits. So taking guidance from our discussion in December and providing updates to the outdated processes for sign installation that I just spoke about, we've drafted the following items into the draft procedures bylaw before you. So a notice of application sign must be posted by the applicant at their cost for OCP amendments and zoning bylaws. And then further details around requirements for preparation, installation, the timing, siting, maintenance, all of those things, which is detailed in Schedule 1. So signs to be posted within 10 days of instructions from staff, and applicants to provide proof of the sign posting within 10 days. And then the signs to be removed as well within 10 days after the bylaw adoption. So we structured the presentation to walk through these motions at each point of each section of the presentation. But if you wish, we can move along through all the details of the presentation, unless you'd like to do these motions now.
No, I think the decision was to make the motions at the end, but I'll pause here just for any questions from council members on this section. So the first one that I have, just in your previous slide, it looks like council has addressed some of those already at the December 11th meeting. If you could just go back to that slide. And that's where, okay, so this is where council has already determined not for temporary use or development variance. Oh, that's interesting. Okay. I was sick. I missed the meeting. So unfortunately the decision was made, but I would just argue that if you're changing use, I think the neighborhood would want to know that, but that's okay. It's been resolved. Councillor St. Pierre.
I'm just curious, in the report, the public information meetings were mentioned significantly, but in the printed information here, we don't have anything coming forward on the PIMs.
That's the next section. We're on signs. We're talking about signs.
Okay, well, what I'm curious about is whether or not the signs would actually have information on the public information meetings if we're requiring them, because that would seem to make sense. I'm also concerned about the language that's used in signs. Often they're a little bit cryptic, and I'm hoping that as much as possible, we can actually make them understandable to the public so they know actually what's going on, not just honestly referring back to a whole bunch of bylaw numbers and so on and so forth. That doesn't mean anything at all. So the signage, I think, should be clear to the public and really informative. And I hope that's part of what happens in terms of either the manual or what's happening here.
So any comments on what would be required in the sign? Anyone? Yeah, like, I don't know what's going to be on the sign. It is just that to Councillor St. Pierre's point.
Yeah, through the chair. So we do have signage templates that have been developed as part of our internal procedures manuals. So I think they reflect generally what they currently do. So there'd be a purpose statement of what the application is proposing, when it would be considered by council if there was a public hearing, and if not, just some general contact information for more details from, say, staff or the applicant.
Okay, Councillor Bateman.
Yeah, so we're going to see a much more modern, graphically user-friendly sign. We saw a City of Vancouver sign earlier in the presentation here. I note that in many communities, there are, at least this is Markham and the City of Toronto, when I say many communities. So in Ontario, a practice seems to be to leave a space for the date of the public information hearing on the sign itself. And the applicant would add that when that date was determined. So perhaps that would be a logical inclusion on these signs.
Can certainly take those comments into consideration. Yeah, thank you.
Okay, Councillor Beddoes.
Yeah, through the chair. If an applicant posts a sign and council's not happy with what's on it, what's the recourse?
Through the chair, may I ask what council may not be happy with?
Yeah, I don't know. I haven't seen a sample yet, but sometimes that I'm not saying it's scrupulous developers, but sometimes that, you know, when you're the one in charge of the narrative, you can embellish on something. And if we feel that it's sort of an unfair presentation, do we have any sort of veto power over what's actually written on that sign?
Yeah, through the chair. So staff would be assisting with the language of the sign and would also approve a proof prior to printing of the sign.
Okay, with that statement, then staff would have the final say as to what's in the thing. If they're not happy with it, it doesn't get posted, or does the developer says, no, I don't care, this is what I'm putting up.
Yeah, I hope we wouldn't have to get into an appeal process on signage language.
Well, I mean, there's that possibility because, you know, I've seen some
Sure.
advertising for various things like liquid natural gas, the recent
Yeah.
one I've seen, that there may be some discrepancies with what's on the sign and what the public perception is. So I'm just wondering what the procedure is. They clear it with you. You say, okay, it's published. They have to do what you say, or you have to do what they say.
Yeah,
Through,
Maybe, I don't know, maybe I'm not clear on that, but.
Yeah, we will generally just be outlining the facts of the proposal. So that'd be a rezoning application from this use to this use to permit or to accommodate townhouse development, for example. It's usually quite clear and agreeable between both parties.
Yeah, I guess I don't want it to be a big advertising for what they're doing. I want the facts on it, what they're doing in relation to the community. So as to say, I'd like to have some control over exactly what's written on that sign, but staff has some ability to deal with that. But yeah, I'm not really clear on that yet. Let it go. Thanks for your answer.
Is it possible to develop like a template? This is what the template sign would look like. You fill in these things. You could put a website, you know, an applicant could put a website for more information, go here, contact this person. Is that generally what we're gonna see?
We have this currently.
Okay,
Yes.
okay. And then anything offensive would fall in a different category and be removed. So I don't see that being the case if someone's trying to get a rezoning, put something.
Staff
offensive up.
approved the proof
Yeah.
prior to it being printed, so we'd ensure all the details necessary for the public and any necessary engagement would be on there.
Okay, good. All right, carrying on, please.
all right, so let's move on to public information meetings. So public information meetings are important to the development application process, as discussed before, to help citizens understand what is being proposed early on in the application process, rather than later on, where a public hearing typically occurs after a bylaw reading. So the formal nature of public hearings also makes it really difficult oftentimes to have that two-way conversation. So local governments are really trending towards relying more heavily on these public meetings to seek community feedback on development. So the current development procedures bylaw outlines that applicants may be required to hold a public information meeting at the applicant's cost. And what we heard from the committee in December is that public information meetings should be required for large-scale developments and encouraged for small-scale developments like mom and pop shops. It was our takeaway to determine how large and small-scale developments would be defined. And then secondly, we heard unanimously that the administrative burden should remain with the applicant to organize and report on the public information meeting. So since December, we have had the opportunity to discuss with staff what the small scale multi-unit housing legislation means for Sooke. And while this is not necessarily a topic for today's committee, we did find an opportunity to use the small scale multi-unit housing framework to essentially define what large and small scale developments mean for this case, for the purposes of requiring or encouraging public information meetings. So we recommend that public information meetings for OCP and zoning bylaw amendments be required for residential developments with 5 or more units, and then encouraged for 4 units or less. And in terms of putting the administrative burden on applicants, what that looks like is that applicants are essentially required to confirm the meeting date, the time, and the location with the district staff. Applicants are also required to advertise the meeting in a local newspaper at least 10 days prior to the meeting. Applicants are required to mail or may be required to mail or otherwise deliver notices to surrounding neighbors. And then applicants would be required to do the facilitation of the public information meeting. And then in addition, committee noted last time the need for staff to attend as an observer, and then the applicant to submit a report summarizing the feedback from the community. So in order to ensure consistency between each of these public information meetings and the engagement report that gets submitted to staff, we've developed a public information meeting guide for developers, as well as an engagement summary template for developers as well. All right, maybe I'll pause here for any questions and we will keep the motions till the end.
Okay, thank you. So this is where I'm a bit confused now. So in this here, it's saying that an applicant for an OCP amendment are subject to do this, but I thought all OCP amendments would come to council and go through a public hearing process. That's what we heard the first time. So this is where the two pieces are being bungled together for me. So if an OCP amendment is needed, which can be done between OCP rewrites, then that requires them to come to council, and council would weigh in on whether or not we want to amend the OCP for that application. So to me, that's completely separate than those who are not required to hold an OCP, any that are consistent with the OCP, but are going through the zoning, which is consistent with the OCP, can't have a public hearing with us, but are encouraged to have the applicant. Does that make sense? Like there's two different pieces here, but they're tied together.
I can jump in there.
Okay,
So one is a private process dictated by the procedures bylaw, granted, and one is a public process. So the public hearing would be where an OCP amendment is required. Essentially where the rezoning application is not consistent with the OCP and therefore an OCP amendment is required in conjunction. That would require a public hearing. It would also require a public information meeting. But where there's a rezoning application that is consistent with the OCP, it would not require that public hearing under the LGA, but it would require a public information meeting if the density would permit 5 or more units. So two processes running concurrently. One is legislated by LGA, the other one is required by our procedures bylaw.
okay, so if an applicant was not consistent with the OCP, but could be supported if it has an OCP amendment, they would do their private engagement with the public and also a full public. Okay. And then if you are consistent with the OCP, but need to amend your zone, then you don't need to have the legislative in chambers, but you need to do you may be required to have your own public input session.
For 5.
So that would be interesting because you could hear two entirely different things. You could have, the developer could hold an open house and receive feedback from some members of the public, and then it could come forward and receive something completely different, potentially. Depending on who shows up, right? More people would pay attention when we hold the meeting, I think, but I could be wrong. Okay, that's interesting. Okay, I'll go to Councillor Pearson this time, then to Bateman and St. Pierre.
Yes, thank you. I recall that in December, we talked about the encouraging the public, and we're starting to see that. Actually, we saw that at last meeting, that the applicant had their own public hearing, and we had a good presentation from that. Public input. They presented it as they had heard from the public about their application, which was good. It was very positive. But I seem to recall, and I'm going to go back, Councillor Beddoes chaired that meeting. I'm going to ask him for his memory as well. That I think that when we talked about this particular encouraging applicants, it didn't include the OCP amendment as part of what the private sector would do. The way that I think the meeting went. I think we talked about it, but I don't think we specifically said, because it felt like it was back to the mayor's point, that it's sort of like the chicken and the egg thing. Like, you're going to require an OCP amendment, but you don't know that until you actually get to council. So I think that we had a fairly robust discussion on this one. I came away from it with a slightly different recollection, but maybe I'm getting old, but and the other thing is that in this recommendation, I wanted to ask a question about the net 5 dwellings, because it's somehow that wording looks a little bit different. Like, so if someone had an additional home, had a home and subdivided 4 lots off the back as an example. Is that 4 or is that 5? Because we did talk about that.
Through the chair.
Yeah.
That would be 5 lots. So that'd be a 5-lot subdivision. 4
Yeah.
additional lots with 1 remainder.
But it's not 5 new, it's 4 new. Right? If somebody divided 4 lots off the back of their property and kept their existing house, is that because that was.
Yeah, through the chair, the way the bylaw is going to be reading is essentially taking a look at the maximum permitted density of the property. So
Yeah.
we're far in advance of subdivision at this stage.
Right.
And if it could accommodate 5 units, whether that's single family or multifamily townhouses, for example, then it would trigger a public information meeting.
Right. But in December, we talked about that. What was the net? And I'm still haven't got clarity on the net. So you're saying if there's 5, if it's an existing house and they chop 4 lots off the back, or they have permission through density to chop 4 lots off there, that's now a major development. So it's a requirement as opposed to an increase of 4 units in that.
Because it's the total. In the end, you have 5 total, not 4.
Right.
You have 4 new plus 1, so it's always what your total is.
Yep. Okay. And I'm fine with that as long as we spell it out clearly that the net, not the existing. Thank you.
Bateman, then St. Pierre.
Okay, so I'm excited about this piece, public information hearings. In the absence of public hearings, these become absolutely critical. And, you know, I regret not being able to have a read of the document you've prepared, which it could be an oversight so the question through you to staff, will that be coming to us to have a review of your guidelines that we saw a brief sample of in the previous slide?
Yes, through the chair.
Yeah.
So we have, I believe these are in the procedure schedules. Is that correct, Talia?
Are those in the procedure schedules? They certainly don't look.
Sorry. Yeah, my mistake then. So they would be an internal document.
Internal document.
Yeah, so terms of reference, we currently have a terms of reference right now, but we would have our own internal document that has some modified changes.
Okay.
As Talia outlined, and then that would be how we guide essentially the public information meetings and provide the information to the applicant.
So in the absence of these documents, I'll just ask some questions because they may well be answered right in here. In person or virtual, can a public information meeting be virtual, or must it be in person?
There, through your mayor, there's options for both. And so the guides do outline how essentially to be able to, or best practices for both virtual and in-person meetings.
Okay, thank you. You've noted in your presentation, you state circulating to neighbors, and of course the bylaw states 100 meters. Now, was there any consideration given to that 100-meter guideline and whether that could be expanded? I understand the Local Government Act gives freedom to local governments to determine that radius. 100 meters really is not very significant, in my opinion.
Yeah, staff, through the chair, staff felt that consistency was important in its radius. So with zoning applications or any type of mailed out correspondence is 100 meters. Right now, we didn't have provisions there to expand that, but yeah, just being consistent with 100-meter radius is where we landed.
So that's a football field surrounding that particular development site.
That's right. In addition
So
to,
it can't be defined as a neighborhood by any definition.
in addition to advertising in the newspaper.
The advertising is critical in the newspaper 10 days prior. And the signage, of course. Now, there was the question of the report. Now, Councillor Pearson mentioned Mr. Morrison was here last Monday night with a really, no, you did not mention his name. However, he did give us a verbal report out, and this new procedure requires a written report. And at our meeting back in December, we talked about the necessity perhaps of council or staff representation at the meetings to be able to give some verification to the report that we received back. There's no question there, but I welcome comments.
Yeah, so certainly the guide would say that staff may be present. It's certainly open to the public, so council may attend as well. And also I guess the details of the report would kind of be outlined within those terms of reference for the public information meetings. And just regarding the question or the instance we had, I think it was last council, the council previous. So they had a public information meeting, Mr. Marsden. That was in advance. That was during an in-stream application prior to Bill 44 taking place. So prior to public hearings being prohibited. So otherwise, a public hearing would have been triggered as part of that application, but they went out as encouraged by staff to hold a public information meeting, and we're glad they did, as it was kind of filled that gap, I think, where the public hearing didn't exist anymore. Yes.
At December 11th, I know I mentioned the idea, could there not be a complimentary or associated website with a public information meeting? So if I've missed the meeting, I can at least get the details online at my convenience. Was that given any thought in this process?
Perhaps Urban Systems could answer that question.
At this time, we haven't pursued additional updates to websites, but there is an opportunity to do that. I saw, Brittany, that you took your mic off as well, if you want to add.
Yeah, through the mayor to Councillor Bateman, I believe it was there. There is an opportunity that you could post that engagement summary online that the developer would be required to provide under the procedures bylaw.
So that's the summary of the meeting itself.
Correct.
And would that include storyboards and all the necessary bells and whistles?
If council wishes for those details to be provided on the website as well, that could be something that staff request the developer to provide as part of the summary as well.
Okay, so that's good. So my comment is this is all about transparency. I know that was in the 2019 report, consistency, transparency of process. So the more information you can provide through these practices, the better. So leave it at that.
Councillor St. Pierre, then Beddoes.
So my concern is actually with smaller operations. So basically you're looking at, 5 or 6 units, or someone just made the cut of 5. So essentially you're just beyond mom and pop. You don't necessarily have the resources of a larger developer. Facilitation is a skill. Eliciting public participation is a skill. Communicating effectively is a skill. The larger developments are going to just pay someone to get it done, get a good report, and they'll probably get appropriate participation. I'm hoping that in what we're doing in terms of the templates and so on and so forth, we can do the best we can to support the smaller developers, because they're going to need help, is my thought. Someone may decide because they're doing 3 units, they've been highly recommended to, they're going to give it a shot. There's no way to know how that's going to work out. And I don't know how that information will come back to. Taking good notes, actually getting the information out of the public engagement session, out of the public information session, it's all going to require skills, is my thinking. So that was a thought. I also have a concern about biases in terms of reporting, depending on exactly who's at the meeting. And in terms of what I think Councilor Bateman was talking with the signage, there was talk about what they call the QED, the symbols that you can actually, potentially point your phone at the sign and then go to a website and actually get the information updated on an ongoing basis from the developer and put your content. I think that's what we talked about. Well, I think that's what we talked about.
Yeah, we did. December 11th.
Okay, so I think I was trying to. No, I'd like to know, what can we do to support smaller developers in this process? Because I think it might be challenging.
Yeah, through the chair. So certainly I think with the transparency and clarity element of this project is really key here. So outlining what those expectations are clearly in written form, which is what we have done internally, at least, and we'll share that document with developers, mom and pop, or larger scale, and create some basic requirements essentially. If they want to take it to another level essentially and have codes or create websites, et cetera, I guess that'd be up to their purview. But I guess you can imagine maybe a larger developer may be more frequent with those skills, that skill set than a small scale developer. So I think probably putting in the ability to exceed the requirements may be a benefit for those smaller time developers. But I think, yeah, mainly it's the clarity and outlining just the expectations in written form for them, and obviously staff assistance with guiding them towards achieving those public information meeting requirements.
Yeah, I'm glad to hear that staff will be available to assist with the process, because I think there's going to be a lot of questions around this. I'd suggest webinars.
But the challenge here, just before I go to Councillor Beddoes, is where you say, have this all on the website. Does every developer, builder have a website? Is it updated? Is it secure? Is it safe? Do you protect it so that it's not hacked into? Like that in itself, like I think is a great idea, but I'm Googling the two in the room. I can't find you online. Right? Because you probably don't have a website that you maintain. If I type in the entities that you work for or whom I thought you did, nothing pops up automatic here. And then scrolling through. So I think that's the feedback we're looking for, because someone who's smaller. So now here's some. I'm not seeing anything in Sooke though on this site. But how much digging then? Like it has to be easy for people to populate. And then in which case, I don't know that is it the district's responsibility if, let's say, the first proposal comes forward, things are changing, then now we need our people to update that and to upload it all onto our site. It has to be in a form that we use, depending on which systems it's developed through. Like in itself, that can create a bit of a barrier. So I don't know where it goes. And when you say post it online, post it where online? Where is it going? Like we have to create a designated website for all of this? Is that the intent? Like where is it landing? That's where like, okay, you post it online. Where online is it going? Who's responsible for it and who's going to keep the data safe?
Yeah, so through the chair, it's intended to be a private process as much as possible here. So limiting staff resources where staff may attend, council may attend, but everything is driven essentially by the applicants themselves to fill that gap where a public hearing is not required. Where a public hearing is required or not, there's still a legislative process that is required here. So mail out notification, in some instances newspaper, and then we take in correspondence as well. And we're developing our own policy. And aside from that, to share with the public and council and to go over a summary of that correspondence received at the meeting. So this is in addition to what's otherwise required by legislation, but yeah, it should be driven by the applicant.
Right. So it's the applicant's website, the applicant posts it, the applicant controls all that information and they're responsible for it fully. And then they need a way though to ensure the public can find it. So then that looks like, I'm just saying it's not, I'm going to go to Councillor Beddoes first and I'll return to you.
Thank you, Your Worship. This is a question that is to the chair. I just state that as outlined in the schedules to the draft bylaw, an applicant for OCP and zoning bylaw amendments are subject to facilitation of public information meeting in accordance with the following, blah, blah, blah. I guess what there is you've got in that an OCP amendment. And now my understanding is the OCP amendments is strictly goes to council, and council after that will hold a public hearing. Is that correct?
Yeah, so in this case, a public hearing is required, with an OCP amendment. Without one, public information is required with an OCP amendment or without, if it's over 5 units.
Still not clear. If it's an OCP amendment, my understanding is it comes to us.
It does.
It does. So why would we ask an applicant to post an information meeting about that, and when we're going to do one ourselves anyways? Are we not? Would we not go to a public hearing on OCP?
Well, I think just Councillor Beddoes to that, like they're going outside of the time frame of 5 years. So we've done robust engagement on how we want things to grow over the next 5 years. In between, an applicant is like, okay, well, I want to do this. The more they get resident buy-in to alters to now change a community plan would be in their best interest, because the plan is signed, sealed, locked for 5 years. You're now coming up in between and you want to do something different. So I think that's where it's encouraged, like go out and showcase.
I understand that.
And then we formally will do our own process as we have to.
I understand that. I just wanted to make it clear that if they go out for a public hearing on an OCP amendments, we're going to do it again anyways.
But it would be here in this room, in a formal setting where we're gonna hear from all sides and make a decision. Staff might bring it forward and say they don't support the OCP amendment for this, that, and that reason, but you may have a number of people that say, hey, we do like this because of X, Y, and Z. These are the nuances of the land and so forth. And ultimately council will weigh all that in, but it's not, but it's a different type of
It just seems
process.
like a duplication. We're asking the applicant to do a public hearing on an OCP amendment. And then they're going to have to come to us for an OCP amendment and we hold a public hearing. So we talk about streamlining things. Now we're going to have 2 public hearings for the same thing.
But it's the same, like we have the odd developer over the years that has an open house because they want to change and do a different phase or do something different from what they already had formal approval to do. So now they're going to the community to see if they can build community support for something. So yeah, it could be, you could have one be successful there, come here and fail. That's the risk of it all, right? Councillor St. Pierre, and then I'll go to Pearson and Lajeunesse.
At this point, I disagree strongly with actually leaving the website or any such thing in the hands of the applicant, and I'll explain. If that sort of thing was done actually on our website as part of our own communication platform, and I see Ms. Moog desperately wanted to say something, so please recognize her at some point. But if that information was actually brought onto our website, then at that point, any comments are automatically going to be part of our website. They're going to be part of a report. If it's a mom and pop situation, it can just be populated by them. They don't actually have to come up with it themselves. They don't have to maintain it themselves. Maintaining a website is not a joke. And maintaining all this stuff is not a joke. It's kind of like we're asking someone who wants a cup of coffee to please learn how to use a barista machine. They just want a cup of coffee. So let's get them a cup of coffee. I think at this point in time, asking your average smaller developer, and honestly, if I go to a developer's website, they're trying to sell me, okay? They're a developer, they're trying to sell me product. Why would I necessarily trust that if I'm the public? I would much rather go to the district website where I know that it's the district, and even though they're gonna raise my taxes, they're more or less maybe on my side. They're not trying to sell me something. So I'm sorry, I really disagree with actually leaving this to the applicant, at least in the shape that I'm hearing right now.
Christina, sorry, you put your hand down, so I thought maybe it had been addressed. I didn't mean to ignore you. Next time, councillors, that's where you do a point of order if I'm missing somebody. Go ahead, please.
No, thank you very much. I think a public information page is something very realistic that we can anchor, and I can offer a parallel comparison. So traffic advisories, for example, when we're notified of planned traffic events, I have a table that's updated. It's easy, it's seamless for staff to update, and we direct it elsewhere. So upon notification, we can provide that as a summary page to Councillor St. Pierre's point. So we have that information. It's not robust as far as staff management. It's within our existing capacity. Where that capacity piece does come into play, though, is posting the content at greater detail, but at least there can be that summary table. That's something certainly staff can take on. We have similar processes in place, whether it's a blasting notification or a traffic advisory events as well. So it's within our existing system and processes. And then that is reliant on the information that's provided from the applicant. So that could be, your sort of fourth column on the page. You've got your information, your file, whether it's a website, great, that we can link to a website, whether it's a simple PDF document that's a one pager within the mom and pop shops, for lack of better words, that opportunity is there to hyperlink. But I hear you on that centrally page where it's a trusted, reliable source. That's certainly available. That's something we can manage, but it would be the limitation on staff's capacity would be that it's a summary public information page. The robustness of the details, managing websites for each individual application is not something staff could take on without a team of developers, to be honest, website developers, to be honest, but there is a tool that we could manage that I think would be a really valuable happy medium. So.
Okay, so I have Pearson, then Lajeunesse.
Yep.
Yeah, just looking at the motion and recalling the discussion, and I know that we're getting back together again. The two final bullets, I think, we're gonna make a recommendation today to go forward, but we have an opportunity at council, hopefully to think about some of these again. I'm actually thinking with the complications of the smaller mom and pop developments, we've got in here encouraged. And then underneath that, there's another bullet that says public information at the request of council and or staff, district staff, required, and the word required. So I think those are kind of, like, I really agree with bullet number 1, 5 or more units, you know, you're required to have a public information meeting. It's not a public hearing. We're getting kind of using words that are different than actually the meaning. So I don't know. I'm going to be thinking about those last 2 bullets and probably not supporting the motion. I don't want to tell you how I'm going to vote in the future, but I think if we just took those out, this would be actually fairly clean.
Okay, well, we'll get
Anyway,
to the
that's another
motions a little later. Yeah, Councillor Lajeunesse.
Yeah, just wanted to address Councillor Beto's concern about the having 2 separate public hearings. The public information session is not a public hearing. It's just to give people a heads up as to
That's obvious.
this is what's coming, and the more formal public hearing is when the decisions are actually finalized. But the other thing is that the public information meetings, I'm a fan of anyway. I always want to kind of know ahead of time before things come to council what's going on, because I have historical knowledge of the community that could be valuable input for the developer and for the community as well. So I've always been a fan of public information meetings.
Okay, good to know. I think we all have some knowledge of various places where we can help inform. So, okay, we'll move on to the next part, please.
Good afternoon, Mayor and Council. Nancy Henderson from Urban Systems, and I will do the presentation regarding delegated authority. Next slide, please. So the first overview, this slide you saw at our last presentation in the winter, but this idea to delegate more to staff originates from the provincial development application process review report that was completed in 2019. It was seen as an area of high priority by the province, and in a way is probably a root of some of the legislative changes that we saw with Bill 26 in particular. The intention was that by delegating to staff, the process does tend to speed up, and there's less administrative burden associated with, you know, the council report and getting the report to council, setting the agendas, and more on council's agenda as well, especially at a time of immense change. So, but it is important, you know, that the local government does delegation in a way that sort of fits your context and feels right for you. And that may depend on the comfort you have in your existing development permit guidelines as an example. So moving on to the next slide, just in terms of a bit of a more of an overview on delegation. Basically, you can delegate authority by bylaw in most cases, which is really a big part of the purpose of the bylaw before you today, except for public hearings, which can actually be delegated by resolution. Very few municipalities do delegate public hearings, although I've heard of some regional districts that have. But examples of decision-making powers that can be delegated would be development permits, now minor development permits further to Bill 26, temporary use permits, and also strata conversions as well. And in some cases, for example, amendments of Section 219 covenants and some other provisions. For delegated decisions, the applicants are entitled to reconsideration or appeal by council. So that is always an ability for them to go before council if they disagree with staff's denial, for example. Basically, the issuance of TUPs or temporary use permits, DVPs or DPs that are subject to conditions established by council are most typically delegated by staff in all instances. They're required to approve to require development approval information, which is a component of this bylaw, is typically also delegated by staff. These are some of the nuances and not particularly a specific application. Determining the appropriate consultation with persons and authorities when you're doing an official community plan is another one that's often delegated. So essentially, setting up like the communication plan for the OCP above and beyond the required public hearings. And this is something that's typically delegated in these bylaws to staff, but often presented to council for further consideration as well. And another one that's come up of late, which is deciding whether an application is consistent with an official community plan, is typically completed by staff in all cases. Otherwise, you'd be getting an application, then going to council and asking council if it was consistent with the OCP. So this is a bit of a nuanced thing that's good to just clarify in your delegation provisions in this bylaw as well. And just looking at this overview slide before we get into the details, and potentially to just avoid some confusion that sometimes happens when we talk about delegation, OCP amendments and rezoning applications are always going to be decisions made by council under our current legislative regime. They are bylaws. I can't imagine this changing. This would be a monumental change. So those major decisions and also the policy setting for the community are always determined by council. Development permits is one area where there's a significant increased delegation that we're seeing of late, and especially in the last couple of years. On this chart, we compare what we're seeing today under your current processes that have been delegated to staff and decisions made by council respecting development permits. And based on the feedback that we've received from council and staff to date, there's quite like nuanced change here. And I'd say this is where Sooke is a little bit different than many of the other communities that we're working in. And some of those communities, in fact, have delegated all development permit authority to staff in total. But they may also have new and approved development permit guidelines as well to provide that additional comfort. Development variance permits typically have always been a decision of council. Technically, you can have delegated staff a DP with variances, but in Sooke's existing procedures, that was very much exempted from staff delegation. But technically, that could have been done. But development variance permits are now able to be delegated to staff when they're minor in nature after Bill 26 was enacted. Temporary use permits is another one that could be delegated to staff, but is elected in the proposed bylaw to remain with council. Our understanding is you're only seeing a couple of these a year. Strata conversion, again, probably something you're not seeing a lot of, and I understand the policy really restricts strata conversion in the district. It is one that we did recommend that be delegated to staff because strata conversions in the district I understand are more at like the duplex scale, so quite a small scale strata conversion, which is quite consistent with many other bylaws around the province. Those communities that do allow a large scale like apartment building type strata conversions under generally with reference to policy, those decisions typically stay with council. And just breaking down into development permits, I know council's very familiar with what a development permit is, but it's also a good reminder for the public and council to really reflect on the fact that development permits are non-discretionary. Both the local government and the applicant must adhere to the DP guidelines that have been approved in the OCP. So if again, when you're creating your OCP and reviewing those development permit guidelines, review them very carefully and encourage public consultation as well, because those guidelines really, if you believe in those guidelines, there should be a lot of comfort in delegation because you can't wiggle out of them. You must adhere to those guidelines when you're looking at the DP approval. And then we've got also, there's OCP designates certain parcels as development permit areas, which require a permit for new development or redevelopment. And that includes even clearing of the lands and development of a parking lot. It doesn't have to be a building, for example. Development permits that are subject to technical development permits are reviewed based on technical requirements and do depend on professional reliance. So they have supporting professional reports. Currently, the district doesn't have technical development permits, which you'll see on the next slide. But your new OCP does have the recommended several technical DPs. So for example, technical DP would be the environmental protection, the foreshore area, riparian area, steep slopes, essentially hazardous conditions. Those type of things are all technical and must be supported by a qualified environmental professional or qualified professional report. And those, I'd say 99.9% of the time in the province are 100% delegated to staff. In your current OCP that's currently in play, you have the town center. It's all form and character. So basically the design of the building only for the town center, community growth areas and comprehensive development designated areas and multifamily residential. So one thing to keep in mind as you're developing this bylaw is that your new OCP has much more development permit areas, and therefore you're going to also see many more development permits. You couple that with the SMU or small scale multiple unit housing, and if you do decide to require development permits for those, you're likely going to also see many more permits just to implement those regulations as well. So the current practices are outlined in your existing bylaw, and you'll see that you have any single family developments, multiple family developments, commercial and institutional with 2,500 square meters of gross floor area, as well as development permits associated with subdivision. And you'll see, like, one thing I was confused when I look at this, but there's another provision that basically has town center areas being exempt from section 4. And another is when there's a variance, as I was kind of talking about earlier. As soon as there's a variance in a development permit application, it automatically would have to go to council. And that could be a significant change for the district is if you do delegate minor variances. If the variance is minor, that development permit could remain with staff. So there is, I think, an important note there just with town center applications remaining at the hand of council. So when we went to council on December 11th, we had a good conversation around delegation then, and there was definitely some comfort with delegation around renovations and small scale multiple unit development or SMU or this sort of gentle density infill that's coming at us. There was also a motion passed that development permits not be delegated for multifamily, commercial, and industrial form and character outside of the town center, which is opposite of what's happening in the current instances right now. And with further conversation with staff, and where staff is delegating DPs to council and feeling that those town center ones are the most contentious, staff recommended that we stick to that approach, and there may have been some confusion in the interpretation at the meeting on the 11th. So the draft bylaw is trying to reflect the conservative approach that council directed us on December 11th to not have a mass delegation to staff or a big change in this area, but to anticipate the small scale multiple unit housing that's coming and to have the 4 units or less be delegated to staff. The multifamily residential developments outside of the town center would would continue to be delegated to staff, and the same provision with commercial, industrial, and institutional with limited 2,500 square meters be delegated. The subdivision alteration of land, when that's triggering DP, would remain. And then for the construction, addition, or alteration of a building, so that was also following council's recommendation. And any existing development permits that don't exceed this authority would also be included. So there's quite often developers will put in a development permit and maybe get to building permit stage and realize that there needs to be some minor amendments. And this happens quite frequently. So it would allow staff to deal with that. And then in terms of this opt-out clause, and this was something that was identified by the province, and we've been including in many of these bylaws because sometimes, you know, there's a feeling by staff that a development permit that's being delegated to them should be considered by council because maybe it's contentious or it's not quite cut and dry in the development permit guidelines as they'd like it to be. So there's an option that we've provided in the bylaw that allows staff to opt out of their delegated decision making and bring a report to council. The other option would be that staff would deny the application and the applicant would be able to appeal. So it would just save that process when staff realizes or feels that there's a need maybe to bring something to council. So it makes it just a little smoother at that stage. And we do have a motion before you, which sort of articulates what I was saying in the presentation, which we can come back to later. And I believe it's a two-part motion that we have that would also be outlined in your report. And my next portion is the delegated authority with respect to development variance permits, but I'd be happy to answer any questions before proceeding.
I think that's a tough one for the director of planning to make that opinion that it's in the public interest. Because depending, you could argue that anything right now that's being developed, the public wants to hear about, because that's a big complaint that many of us here receive. So that's a lot of pressure, I think, to put on an individual to then say, no, it's in the public interest for you to go before council. I don't know what that looks like. I'll ask our manager of planning right now.
Yeah, just one comment there. I guess public interest can be defined in many ways, right? There are many public interests. It's challenging to balance all those interests, but one reflection of the public interest would be your official community plan, right? So you usually there's significant engagement, guidelines, et cetera, would be developed with all different stakeholders. That document itself should be representative of the public interest to a large degree.
It's a good answer, but yeah, okay. Councillor St. Pierre, he is, but I'm just saying, look at what we went through with that document.
This is my own interpretation, but I get the sense that the job of the director of planning to basically determine. I think this application is not reaching consensus between staff and the applicant. Therefore, it's probably going to come back to council anyway. Let's save some time and take it directly to council. I think that's part of the public interest as well, just saving time. And if something's contentious and if the applicant and staff are not coming into agreement, then bring it to council so the council can resolve the issue. And so it's brought forward immediately. I think that was my sense of this, and I don't.
Yes, through the chair, that's my understanding as well. If the director determines that there's some sort of contention, one or more elements of the proposal, then they have the ability to opt out and bring it directly to council. Exactly.
Okay. All right, so questions on this particular section here. I'm going to put it out there. I struggle with any delegated authority at this stage. It's all due respect to everyone in the room, but with the province cutting the public out completely, and then, you know, we give notice that something's happening, but we can't do anything to make it look like it has a public hearing. Essentially, it's now we're here making all of these and then shifting it over to staff. So I can see why the province would want us to do that because it fits with their mandate, but it doesn't necessarily reflect ours. There's been a lot of, I don't know, not interesting interactions downstairs between municipal staff and applicants that haven't always seemingly seemed collegial from the outside. That doesn't seem like people are necessarily happy with our staff or getting the results, and it's doesn't seem very positive all the time. And it's staff defending the policies that council has actually put into play. So any of that frustration should actually come to the decision makers that put the policy and adopted it, not to our staff who are just trying to carry out the will of council and the work that we've adopted here. I've always struggled with delegated authority when it comes to renovations. Okay, it makes fine, or if it's a demolition of a building that's falling down, that makes sense. But with sweeping changes that have been made, I think you mentioned Bill 44 and what's happening, the average person isn't fully aware of that. There's too much going on in the world in their lives right now. And so they put their trust in us to make the decisions in a way that's transparent, that they can follow. They can watch webcasts, they can read the minutes, they can see what's happening. And it's a very transparent process. It needs improvement, but it's still open and available. We at council can't spend $50 without it coming into this room and all of council ratifying that. Sponsoring scarecrows for the fall fair requires a council resolution, and that's under $50. And yet we're willing to just hand this all downstairs where there is no public oversight. So it's just my opinion. It's where I disagree with the province with what they're doing. And I struggle just eliminating the public for housing that is dramatically going to change neighborhoods that as they are as we know them today. Okay, so I'll go to Councillor Pearson this time, then to Councillor Bateman and St. Pierre.
Well, first of all, thank you. I 100% agree with you. It feels counterintuitive that we've been elected body to make decisions on form and character of neighborhoods and things like that. And delegated authority is that, and I know times change, and I've been around here for I don't know, 13 or 14 years again. And I struggle with this part of it. I'll be very honest. I concur with your comments. There's parts of it I fully understand, and in the effort to speed things up, sometimes it feels like this is going to be slowing things down, and maybe the proof is in the pudding and you know, the actual application, but I don't know, somehow not knowing what's going on in our community, which is incumbent upon me to know, feels counterintuitive to what I was elected to do. Anyway, that's it. Comment.
Councillor Bateman.
Yeah, it strikes me that this delegation for development permits is already built into the current development permit delegation bylaw number 705. And with the new wrinkle of this option for the applicant to take it to council. I don't believe that was in the previous delegation bylaw. So I'm in favor of this particular motion.
Councillor St. Pierre?
Yeah, I just want to reiterate.
We're not on the motion. I was commenting, but we are still just generally on what's coming on, right?
Just in response, one more time, and I want to just make this really clear. If there's contention, you know, between applicants and staff down below, we're going to hear from it. We haven't given up our responsibility. We haven't given up our rights. We're going to hear from it, because if those people are not actually getting what they want from staff, they're going to come to us because they have the legal right to do so. So what we're doing is we're saying, you want to be in the sewer catchment area and you're right on the sewer catchment area. We missed that. Okay, boom, done. This doesn't come before council. You have every right, according to the new regulations, to get, you know, 4 units on your lot, and we've got everything in place. Boom, it's done. The province is putting huge changes all over the place. When our mayor was talking about, you know, the average person, in a lot of ways, we are the average person. Okay. That means that if we're actually getting involved with decisions where we don't need to, like sewer catchment and so on and so forth, we're doing the opposite of streamlining this process. the development community and people that we serve, and part of the service is actually providing building permits, developing permits and getting things done, are not going to be helped by us actually trying to figure out the job that our staff is paid to do. That's all there is to it. We're still there with staff support to try and figure out the contentious issues. And we'll have to, because they're going to come to us anyway, which is the weirdest thing of all, but in some ways necessary. And I get that. The other thing is we're talking about not having access to the public and the public not having access. I believe that what we're doing right now is trying to put in, because of this, way better systems than we ever had before for the public to have access and for them to get better information in, making sure the correspondence is attached to reports, making sure that they can get in early, making sure ideally we've already done it in terms of, when the first reading comes up, providing more time for people to actually say their piece. These are all ways that we're actually mitigating that particular impact. We're doing everything we can, and I think we're going to end up with a better system overall. Don't know if that's what the province was looking for, but I think that's what we're going to try and do, and that's what we're moving towards. But while we're going through this whole process, this is meant to actually streamline a process which everyone in the community, us, staff, the development community, and residents, says is slow, cumbersome, and hell on wheels. We do not want to be what's getting in the way of making that work. And we have recommendations from the province, from our consultants, and from staff to maybe consider getting out of the way. So I think we should consider it.
Others? Go ahead, Councillor Lajeunesse.
Yeah, I think if it'll speed up the process, I don't have an issue with it. It's just that I think that some of our bylaws need to be looked at prior to this, because I think we've seen in the past where things come to council because the bylaws don't necessarily make sense in many cases. And so I think this is a little bit premature until we get our bylaws kind of straightened out. Once the bylaws are set up properly, then sure, it's easy for staff to make those decisions. But sometimes due to our bylaws not being perfect in many cases, it becomes a challenge. So yeah.
Councillor Beddoes.
I find it all kind of confusing in the fact that we don't have a current OCP. We're dealing with one that's, I don't know, a dozen years old, if not more. And the present one that we're going through probably has to be amended too because of all these things. So I agree, we've got the cart before the horse here, but I guess we've got no choice but to proceed with it. But it is frustrating because we need to develop, as Councillor Lajeunesse says, we have to look at those bylaws. We can't look at the bylaws until we pass the new OCP. So it's a frustrating moment, but I guess we'll just have to carry on and amend things after the fact. But it's province has put us in a very difficult position.
But just to that, council has that option, right? So I can't find the screen that showed, I don't have it in the materials. What would be helpful is to have the PowerPoint from Urban Systems circulated to us. In one of the slides there, it indicated the number of bylaws that would all sort of be consolidated into one. But council could, like, it's our responsibility making, our decision making can be delegated at any time. It can be changed when council sees fit. So it's possible for us to work through this consolidation, have a different development approval process, bylaw, whatever it's called, application procedures bylaw in place, address the OCP and the zoning bylaw, and then take another look. How are things going? And then at that time, okay, we can delegate this authority to staff. It's the same as spending. In the time that I've sat here, council had approved authorization of invoices to the district for this amount. And then it was thinned down to a point where staff couldn't even pay the hydro bill without it being vetted by council. And then we realized that that's not a good practice because we're paying late fees on bills. So it changed to allow for different capacity. And then the financial house is in order, awesome audit report and the like. It's not a concern. So there's an opportunity where it's our decision making. Do we want to pass that responsibility or do we want to keep it? It's not finite. It's not forever, this moment in time. So we heard from a member of the Sooke Buildings Association, they prefer to come to council. That's a user of all of this. And maybe in time, they will become more comfortable and say, okay, actually, you know, staff, maybe you were right then. It would be faster if we did X, Y, and Z. But there's a lot of unknowns as everyone is trying to move through the bylaws we want to see, what our transportation planning should look like, what the province wants us to do. I just feel it's too early. And we're elected to make land use decisions, protective services decisions, and everything else. It's part of our function to sit here and to just go through these things on behalf of the public and everyone else. Councillor St. Pierre.
I was wanting to address something that Councillor Jeunesse said, which was about the bylaws. The OCP is meant to be actually refreshed every 5 years, which means that we have to refresh the bylaws theoretically every 5 years. Meanwhile, the bylaws are in an iterative process where they're constantly being amended and refreshed and changed potentially. Policies are being re-examined regularly. There is no actual perfect bylaw. This is all a great big ongoing cycle of trying to improve them and make them better and trying to make them fit a changing context. And the context is changing fast, so fast. So what we're doing right now and what the province will mandate, you know, in a year or two, this conversation may be moot. A year from now or 6 months from now, if we haven't moved on this stuff, they may just mandate all of this stuff. And that'll be that. And then we'll scramble to deal with it then. Point being, we can't actually wait until everything's perfect. The perfect cannot be the enemy of the good. We need to move forward, best foot forward, and try and get this development process working. We have a responsibility as elected to provide good governance and to make sure there's good policy to guide staff so the community's vision of the OCP is realized. It's not our responsibility, or I think the community's wish, for us to be in all the weeds, especially when all we're doing is potentially slowing down the variances that would be accepted anyway. I don't know how many times council has ever said no with a staff recommendation on a variance.
Just point of order, we've been split many times. In our last meeting, we couldn't even conclude because we were tied.
Absolutely, when the staff does not recommend it, but on any variance that comes forward with a positive staff recommendation, we have generally said, yes, these are the only ones we're talking about. These are the only ones we're talking about. The other ones are going to come forward anyway, just the way they have been. The change we're looking at is the ones that would be a slam dunk anyway, we don't deal with. I don't know why that's so scary.
Well, if the province mandates one province over, there's interesting legislation occurring there that is really removing an order of government that I think is most relevant, and that's the local government level. So I would just be careful about the province coming in and mandating things, because then, yes, they can do that. We're a creature of the province, as they like to remind us of such, but at the same time, we have a very important role to play and interests that need to be protected, and it's not one size fits all. So I think we'll see what comes from that, but at the same time, I don't know, while we're holding one downloaded responsibility after another, it's a lot just to have our authority taken from us. So it may be, you know, we can agree to disagree. I would just be careful about wanting the province to mandate anything. We should all just stay in our own lanes. Councillor Pearson.
Point of privilege. I've drank too much water.
Okay. We'll just take a health break here. It's, what time is it? Synchronizing watches. We'll be back at 3. So that's in about 8 minutes. Okay, everyone, we are at 3 o'clock, so we'll resume our meeting. Thank you, everyone, for standing by. So we covered off, that was our delegation of authority piece. What lies next? I think there's still more to that, perhaps.
Yes, Mayor, there's some additional delegation of authority requests, and the next one is minor variances. Okay, so what is a development variance permit? I know council sees these quite frequently, I imagine. And often they're standalone variances to the zoning bylaw or the subdivision development services bylaw, but they can also be attached to a development permit where they're requesting a setback change or a height change in conjunction with that DP. Development variance permits cannot vary use or density. If they do, if an applicant did want to do that, that would be a rezoning application. Variances that are typically requested would be height, setback, lot width, development servicing bylaws sometimes might be access and timing of service requirements, or potentially frontage requirement that's at the authority of the subdivision improving officer. What we do want to reflect on as well is there is another way to vary bylaws, would be the Board of Variances, which the Board of Variance is a requirement of the province to have one. Many municipalities have them but don't use them too frequently. But it is an example of where variance approval has been delegated to a public body of private citizens that are not professionals to vary the zoning bylaw, for example, which it's meant to be solely based on hardship. And hardship is an undefined term, so it's left to the body to determine what that is. So although this was a big change by Bill 26, it's sort of easier to understand, I think, when you reflect on the Board of Variance, that it isn't as big of a change as one might sort of think at first glance. The Local Government Act in section 498.1 is what was changed with Bill 26 to allow the delegation, but it's very specific to zoning bylaws, to off-street parking, loading space requirements, regulation of signs, screening and landscaping, and or another provision prescribed by the Lieutenant Governor. So it's not subdivision servicing bylaw variance, for example. That would be outside the scope of minor variances. And the legislation does state that the local government must establish criteria to determine whether the proposed variance is minor in nature, and guidelines that the delegate must consider when deciding to issue a minor variance permit. So just as I noted earlier, in your existing development procedures bylaw, as soon as a development permit needs a variance and it's being delegated, that would remove that delegation to staff and put that application before council. Is the way that it's currently written. If council wishes, if there is a minor variance associated with the DP that you have delegated to staff, that would negate that situation having to come to council, but only if it was minor in nature. So when we discussed this at the December 11th meeting, we received the following direction: that minor development variance permits be delegated to staff where the variance would have no significant negative impact on the use immediately adjacent or nearby the properties, with the exception of parking, and that council require notification for minor development variance permits over and above the Local Government Act requirements. So another item that we noted on December 11th was the legislation doesn't require written notice to go out to adjacent property owners for minor variances, but when it's a development variance permit being decided by council, the notification is required. So based on this recommendation from our last meeting, we've incorporated the requirement for a notification to go out for delegated minor development variance permits as well. And then staff could also consider the feedback received from the surrounding neighbors into their decision to approve or deny the application. Many municipalities are also concerned about staff doing parking variances. They tend to be quite contentious. We do recommend, however, that in the case of a commercial parking variance where you have a changeover from one use to another in a developed property already, so you'll see that sometimes where you maybe have a personal service type use that had a lower parking requirement, have a tenant improvement and go into say retail use that might have a higher parking requirement, but the property is fully developed and they can't create any more parking spaces. So in those types of situations, you may wish to delegate those types of situations to staff because they're municipalities between a rock and a hard place, and eventually change your parking requirement so that they're more consistent would be another consideration as well. The draft procedures bylaw that's before you does have the delegation to the director to issue minor variance permits, and with the criteria that's outlined, so having no negative impact on the use immediately adjacent or nearby properties. Now that would be something that would be gauged by the requirement of the notification, and also increasing that notification to be standard 100 meters as per the other notification in the bylaw, instead of just the adjacent properties, which was previous. So more people would actually likely be apprised of the application. And I think that would give staff the ability to try to mitigate any of those concerns. But if those concerns couldn't be mitigated, then that would be a reason to consider the variance no longer minor. And looking at the degree or scope of the variance relative to the regulation. So, I mean, if it's a very significant variance, then that would no longer be considered minor and go to council. And sometimes, you know, is it consistent with the general purpose and intent of the zone? Sometimes if you have a really large lot or it's on the edge of town, you know, it's not as significant to require those types of variances as in a tighter situation. And that there's a valid reason for the request. And sometimes that might be a natural feature or wanting to preserve a tree on the property, for example. In deciding whether to issue the DVP, the director must consider the following. So these are the guidelines, so that there's a physical or legal constraint associated with the site. So this is, in a way, kind of like the hardship provision with the Board of Variance. There's a community or environmental benefit to the variance if it could help facilitate affordable housing or protection of a wetland or a tree, for example. Those types of things that would be factored into the decision making, as well as not including the number of parking stalls. And this is what I was explaining earlier, unless there's a change of use that's associated with the business license application. Proximity and impact to the variance to the neighbor's property, like how the director would have to kind of weigh how those neighboring properties are impacted, and also there would be the notification option as well. And if this was a major change to the surrounding neighborhood, then that would no longer be considered minor. And also considering that strict compliance with the zoning regulation would be unreasonable and very difficult to achieve what was being applied for. And so with that, we also have outlined the delegation. It's been broken into two separate motions, but we've got here basically that council delegate the director of planning the issue to issue minor variance permits, sort of outlining some of the criteria that we had established, as well as the guidelines that we've outlined have been broken down into the motions before council for consideration at the end of the meeting. And before we move on to strata title conversion delegation, does council have any questions?
Hey, questions, Councillor St. Pierre?
Just a quick one. What defines valid reason? Is it just up to the discretion of the director? Is that the idea or?
Yeah, yes, through the chair, that would be something that the director would need to reflect on and consider. And I think what we don't want to see, and some municipalities have used more of a prescriptive approach, and a lot of those municipalities were more early adopters. And I think they've run into some issues where if it was like, oh, a minor variance is 10% of a side yard or any setback, and then people could come in and just essentially request a 10% variance to the side yard setback. And that's not something that we would want to see. We would want people to uphold the regulations that were set out. But if there is a valid reason because somebody, could shift the house or development slightly to have a preservation of a tree on the other side, that we would see as valid. So it's kind of using discretion that there's a reason for the request.
Go ahead.
So if I can interpret this a little bit, this would be encouraging basically director of planning to use their discretion to make things happen, which I think is something we've actually wanted to see. Am I understanding this properly?
That would be my interpretation, and having many years as a director of planning, there's a lot of times, and I think that councils that I've reported to are often have this feeling like, why is this application before us? Because it's just so commonsensical, and it just would save everybody's time if it was delegated. And sometimes there's other situations too, where you might have a foundation that's poured 2 centimeters off, that's incorrect, that technically needs a variance. Those types of things could be dealt with at the discretion of the director.
Thank you very much.
Can you please speak a bit more by that bullet? It says if strict compliance with the zoning regulation would be unreasonable. I can't follow that.
Yeah, that would be a situation where, it's sometimes, the zones are developed. I mean, they've got a very broad brush situation, across much of the municipality. And there might be a lot that's a existing non-conforming lot size or a strange shape that would be very difficult to place a sort of a standard house on without, say, a slight side yard setback, or shifting the property on a pie-shaped lot further into the rear yard setback. And it would be difficult to develop on that property without that variance in place.
Okay, I get that, because that's kind of addressed in the first bullet where it's talking about the constraints with the sites. Like it talks about the unusual parcel shape and the like, and I can appreciate that. But then this is at the end. So I just don't, what you just answered seems to cover the first bullet. And that's why I don't get this one.
There's potentially some redundancy there if you were to look at it that way. But I think what we wanted to make sure is that if there was a sort of a valid reason not to apply for the variance, like you could still build that house by fitting the pie shape and it's more like personal preference, it would be a test to say, like, you know what, if you shifted the house a little bit over this way, I think you can meet the zoning, and there would be a reason to potentially deny the request.
Okay, and just it almost seems that it's not necessary to include that, but we can get to that when we deliberate on it. The other one is in regards to the parking stalls. Were an increase. Okay, a reduction in the number of parking stalls, except where an increase in parking is associated with the change of use and no more floor space. Okay, so this is a built-out environment, but in most cases, landlords seeking a tenant would require that the prospective tenant conform to the existing bylaws of the day, because you can't create more parking. So then that becomes a problem down the road for the municipality later if there's not adequate parking for that use. So then maybe it's not the right fit for that location. Any comments on that? Like why that would be in there? Like I get
Yeah.
we're trying to grow the commercial space, but if residents can't access the business, they're not gonna go there anyway, because they can't get to it.
Yes, Mayor, what I find just in terms of sometimes parking bylaws, and I mean, it might be something to be looking at carefully as you go into 2025. And I haven't reviewed yours in detail, but there's often slight changes between different uses in the parking bylaws. You could see them all listed. And, you might be talking about 1 or 2 spaces, not like a wholesale change, because generally, I mean, you should be factoring that in when that property was developed. So in order, it's generally just a business license, like the zoning would fit, like the land use would fit in that particular development because it's listed as a permitted use in the zone. So then quite often you get businesses coming in for their business license, and then through a more detailed review, you see that the parking might be off by 1 or 2 stalls. And then at this stage, they're at a point where they're almost ready to open, and they're going to need to apply for a parking variance technically before that business license can be issued. So it's one of those ones that it tends to be a bit tricky and emotional and time consuming. And it might be one that council may wish to consider delegation because of the nature of these types of requests. But if council has lots of concerns regarding parking and wants to be the decision maker for those, and that might be something that you may not wish to delegate.
And just
Okay,
a
now
comment
it's-
here as well.
Yeah.
The director would have the ability to opt out with these minor variances. If it was more significant, if it was not one stall, 2 stalls, they could of course bring it to council.
Or it could just be communication. I'm just thinking of places where this is an old example. Okay, so you go and you buy a computer back in the day and it had a really big, heavy monitor. And so maybe this isn't a good example. You're trying to pick up something bulky and there's no parking. You can't do it. There's nowhere to park on the street. You can't carry that object to your vehicle. There's no carryout service. In this day, you're just going to buy online. So because it's too much, it's delivered to your door versus carrying something awkward to something. Or, if you want to drop into something and if you can't get there, you're going to keep going. And so it may be the case where, I think it's just a heads up, like it's just, are you sure this is where you want to locate? Because you are in a built out environment and it's going to be difficult to access that. Let's say we had a place open and sell mattresses and then there's no parking. Like, how are you going to carry that down the road? So unless there's an opportunity, like I'm just thinking of, it's weird personal examples, like one time helping a friend bring a tuba in to get this thing fixed. Like it was a nightmare carrying it down the road. Right. So it's just, it's life, right? But it's just how you want the business to be successful and we want more commercial interest. But if they can't get parking to access, and there was one time I parked in a place, my kid was in a child seat. I couldn't get him out of the car because the parking spot that I fit in was narrow. Now I see it's marked for motorbikes only. I couldn't even get out of the vehicle. And yet it's meant to be a family friendly place. So it's just trying to help the business succeed as best as we can. Like I'm fine with this, but it's just the reality of life sits in. And if you can't get in there, you're not shopping there that day. You're going to carry on and go somewhere else. And that doesn't help anything. So you don't have to answer my weird examples. Councillor Bateman.
Thank you for all of that. The sight of that tuba going down Main Street is delightful. So I think these criteria and the guidelines are absolutely clear and concise. There is still another option here for the director to consider the public interest. So my first recommendation in your definitions in section 2, I would add public interest. So let's see what that might mean. That would be my recommendation. And secondly, I was curious to just run that through a couple of recent matters. We have Croydon Place and Silver Spray last week. Now, those were development, theoretically minor DVPs. Would you have brought those to us
Those were different, just, I'm going to interrupt you, Counselor
Mm.
Bateman, because in those instances, it was the applicant seeking the variance and it was not supported by staff. For both of those. So in those cases, those will always come to council. But we could use Macola Housing for an example on charters where the applicant and staff had supported a parking variance that council did not support, and we ended up finding a midway approval on that. So that would be an example where it was a split vote in the end, but we came to an outcome, but there was a reduction that was sought that was supportable. So that would be an example. The others are all would have come anyway. So a bit different. Okay.
Public interest in the definitions, please.
Counselor St. Pierre.
It's definitely more of a comment than a question, but I'm noticing the word unreasonable with the valid reason. And I'm so happy because I think the most common complaint I have from people in terms of the development process, in terms of permits and so on and so forth, is I have no idea why they can't just make this common sense decision and do this thing. And then I have to very carefully explain, well, the staff have to follow the rules, they don't make them. And this actually is a rule saying you must be reasonable. So I'm thrilled to see this because it actually gives the latitude for ideally fewer people to come forward saying, I have no idea why this even had to go this far. I have no idea why it was so hard. Why couldn't someone have just said, this makes sense, do it. It's because there's no rule. And this is the first rule I've seen like that. The valid reason in this, these are the first rules I've seen that actually say, please.
Okay, anything else from anyone? And we'll move to the other section. Okay, we'll go ahead. Thank you.
Thank you for that feedback. And the next and final section regarding delegation is regarding strata title conversions. So something not quite as popular along the council table, I'm quite sure. And I believe you have the next slide outlines your current practices and policy. So currently council is the approving authority for all strata conversions in the district. My understanding is that strata conversions of larger scale developments is not supported by the policy. However, so most of the applications that you're seeing are for duplex strata conversions. And so these sort of 5 elements that we've taken from your existing policy and placed it into the delegation with the recommendation that these duplex strata conversions be delegated to staff using the same criteria. Council may wish to have a provision that's more sort of crystal clear or definitive for A, like the priority of accommodation over privately owned housing in the area. Some municipalities will use like a specific vacancy rate, like 2%. And so you may wish to have delegation to staff when there is a 2% vacancy rate and greater, for example, and otherwise they go to council. You could do something like that. But since you're only looking at duplexes, a lot of the review really is about the life expectancy of the building and includes building officials. And then the big issue is just what to do with existing tenants, and that's usually that's also part of the application process that the applicant outline. So we have a motion there, which really is just a reflection of using the same policy framework, delegating duplex strata title conversions to the director. And I'm not sure if council has any questions on strata conversions. And if not, I could just go through the next slide, which is something you've already seen before. And it's just sort of a wrap up summary illustrating what we discussed at the beginning, but really kind of encapsulates the changes that are being suggested. So with the development permit, we've taken a very conservative approach and reflected essentially, for the most part, what you have in place right now, and also reflected the SHMU zoning with the 4 units or less that are coming down the pipe by the end of June, and you'll likely see more types of that development, and generally fairly minor nature development permits that we've recommended delegating to staff. I think it's also of note to you as council's coming into the decision-making part of your afternoon is I believe most of the delegated decisions regarding development permits and are the non-delegated decisions that are coming to council. Council aligns with staff recommendations the vast majority, I think close to 100% of the time, and that they're, you know, again, the municipality is bound to your existing guidelines, and that the public doesn't have a place in the development permit review process. There's no public consultation component of that based on case law and the legislation. The key for the public is to get them involved in the development of the development permit guidelines. And then we've got, with development variance permits, the minor, as we have just discussed, being delegated to staff, temporary use permits remaining in council's hands, and strata conversions for duplex type units being delegated to staff. And that concludes the delegation section. And I know Brittany was going to take over on the wrap up portion. But council may wish to discuss the motions before getting into the next steps of the bylaw. And does council have any questions from me before you turn to the motions on the table?
Anything for our consultant at this time? Go ahead, Councillor Beddoes.
How do we determine, this is for staff or consultant or anybody, how do we determine the vacancy rate?
That's a good question. How do we know that? Here in Sooke.
Yeah, through the chair. Oh, sorry. Yeah, through the chair, usually CMHC would post that data. We can also create that data ourselves, but yeah, based on the rental accommodations and the vacancy of those accommodations. Currently, it's under 2%.
Interesting. Councillor St. Pierre.
It's just another quick question for staff. With regards to rentals again, what are the provisions in place right now in terms of strata conversions for protecting renters?
Yeah, generally these are reflected in the Residential Tenancy Act. So there's compensation, notification requirements. Some municipalities do go above and beyond that in more robust policies, which we currently don't have. But yeah, it's usually the RTA, which would dictate the provisions there, or protections for tenants. If there's conversion of a building, they could remain unless the owner of the building decides to occupy, or family members.
Follow up. I'm not sure if you'll have the answer to this one. I know that the province has recently put forward new legislation with regards to rent and landlord relations and so on and so forth. Do you know if they've made that piece of it more robust and what that might look like?
Yeah, I believe you're speaking to Bill 16. I'm not 100% familiar. Maybe Nancy would have a good answer to this.
Yeah, through the chair, I just wrote down Bill 16 review as you're asking that question. I did review it when it first came out, but not so much to the eye of strata conversions. And I'm sort of, something's triggering in the back of my mind there that we should do a review of that as well.
Okay,
but it is yet to be enacted.
Yeah, I'm just curious as to whether or not we might be too early and adding an additional level of complexity when the province is already potentially beefing up that stuff anyway, but I don't know. So
The other one was strata conversion. There was one that we've dealt with, but I thought it was the strata was the road or something. So does that apply here? Like, I think it was the same number of units. I don't think it was the case, just going off of memory, where there were units that were going to become rental, or like the strata was something else.
That's correct. It was a duplex residential strata conversion. In this case, a list of conditions. So approval in principle is granted by the approving authority, which is council. It included frontage improvements. Some of the conditions that we can make as part of the strata conversion can include upgrades to services, or in this case, road frontage. Again, if there's an appeal process or an opt-out, that could be possible here as well. So it could end up going to council if it is not as straightforward as a more straightforward one.
Thank you for that. Where did I see another hand for queries? Okay, go ahead, Councillor Bateman.
These are just a few very minor housekeeping items in the draft bylaw. So on item 10 on page 30, there's a sentence that reads, when a permit is to reconsidered by the council. So I'm not quite sure what that means. On page 32, you have ordering of numbers incorrect under processing procedure number 3. And on page 45, under item 7, there is a reference to bylaw 65, which precedes the current subdivision and development standards bylaw. So that's a little piece of ancient history that snuck into this otherwise immaculate bylaw. Thank you.
Okay, thank you. So if that concludes our presentation of the meeting, I'd like to see if the current member of the public would like to address council. For those viewing online, we do have one individual in the room here today with us.
Thank you, Your Worship. Malcolm McNaughton, resident of Langford, developer of several properties here in Sooke. Just wanted to take an opportunity to give some feedback to the council and to staff on this bylaw. Having worked as staff under using delegated bylaws, I do have some practice as a planner with this type of situation and how it particularly works, where everything doesn't necessarily go to council. And so I think I have probably a slightly different opinion than Mr. Haldane had expressed earlier. I think I would say though, however, that each municipality is unique, and their relation and council's relationship with staff in each situation is also unique. And I think that needs to be taken into consideration in terms of how you operate. One thing I guess I'd like to say is that when you get into doing any type of bylaw, especially something in procedures that kind of touches a whole bunch of things, the devil is really in the details. And there's a few details I think that I'd like to bring up that I think should be looked at or could be looked at just in terms of additional information, different additional consideration. And I guess the first one is there's a reference in comprehensive developments to terms of reference, and having the terms of reference be approved by council before a project can go forward. And so in my work in other jurisdictions, that's not a typical piece that I've seen. And what I have seen in some jurisdictions is that a terms of reference is based on a template that, for example, in Nanaimo, they have a transportation, they have terms of reference for transportation studies. So there's things that can be set out, whether it's transportation or environmental or whatever it is, that's set out, so it gives people a guideline of what they're going to do through that process. And I think, if you have good staff that you trust, you can use that almost as a checklist and say, okay, well, this one doesn't apply in this situation. You're not within, say, 800 meters of a highway, of a provincial highway or something. So you don't need to do that portion of it. And I think there's things like that could be put into this bylaw that really would be helpful to be able to move things forward without having to come to council over and over again. The second thing I wanted to bring up was in the reconsideration of council, an applicant has 30 days in which to make an application for reconsideration. However, there's no time frame within which council has to actually hear that, or it has to be brought to council. So again, I guess I'm just bringing that up. Is that something to consider in terms of, is there some targets there that can be put in for that? Because what can happen in a situation is that if a applicant is denied, It's also the staff that holds the key to get to council to actually be able to hear that application. So it's good to have some checks and balances, I think, in terms of that. One of the other items that I think was brought up by councillors, I think it was St. Pierre, maybe it was Mr. Bateman, that I found interesting was the cutoff of new information between council meetings when you have first and second reading or first, second, third, and adoption. Under the old way of doing things, after a public hearing, you could not accept any more information. And so now that isn't really clear to me as to when that cutoff is and how it is appropriate. And I guess there hasn't been a robust discussion around that, I would say. And so I think just from a procedural standpoint so that it's clear for not only the developers, but for the public and for council, when you're receiving information, can we receive it all the way through? Or now is there a cutoff after first, second, and third? Or what is it and make it very specific, I think, so that everybody's got the same playing field, I guess is a good way to put that. The other thing that I think is also important here is allowing staff to delegate to approve with conditions. One of the things that it talks about council approving with conditions, but the bylaw doesn't actually speak to specifically allowing staff to provide conditions. And I think that's an important piece, because I think one of the things that I've seen in the past where staff has been good at being able to balance, neighbors and public interest, is to be able to provide a condition. And if they don't feel like they have that in the bylaw, then it might just automatically go to council. So just something else to think about there. The other thing I think in here, it talks about the Sooke Development Review Committee. And I guess I know of that committee, but I'm just wondering, is there a terms of reference for that committee and how often they meet? And is there some more pieces around that I think could be maybe not in this bylaw, but dealt with? It's kind of one of those ancillary things. Like I say, the devil is in the detail. When you have a bylaw that touches a lot of different things, it kind of triggers some other considerations as you're going through. So just some more consideration around that. And then I guess my other question would be through you, your worship, to staff. I was a little unclear about the density on where the delegation would have or not, because it was mentioned that it would be based on density. But if I came in with an application that limited the density to under the delegated limit, would that, even though the potential, like if it was limited and I agreed to a covenant, would that then still have to go to council if the potential was there in the OCP? Or is it okay to go forward because I've been self-limiting in the density that I'd like to have? So that's a question that I think I'd like to have answered just in this. The other item was on page 12. It talks about number 23. It talks about 6 months of inactivity. Honestly, I think this should be a year. There are certain things that happen out there in the world, whether it's COVID or other types of things that makes 6 months challenging. And, certainly even if there was a process at 6 months to request a 6-month extension or something would be, I think, reasonable. Just a couple comments now about just general things. I've kind of gone through my list of all the items on the, then it is related to the bylaw, but I just more generally, not specific items within the bylaw. There was a mention as we were going through this that one of the challenges that the government has is the ability to keep up with change in society. And I think, there's two sides to that coin of trying to get it right. And then there's also the coin of trying to keep up with all of the changes in society. And I think we just have to keep going and try and do the best that we can and not be afraid to make changes along the way, that these are kind of living documents as we go. The other suggestion, I guess, that I would make in terms of the ability to have public input on a wider basis is the use of committees. You know, I sit on the Sustainable Development Advisory Committee in Langford. We see all of the rezoning and OCP changes. We see some of the policy changes. It gives the public an opportunity to actually come in front of part of council and the community to say their piece and to ask good questions. We answer a lot of questions on that committee, and I think that's a really helpful piece as well. So that's something that I think could be considered. So I think with that, I think I will leave it. I appreciate the time, and thank you.
Okay, thank you for hanging in there with us. I just sort of made notes here on some of these things, so I'm just wondering if staff have any reply to some of the queries that have been raised today. I'll answer the easy one on committees. We've just been waiting. Now that we have our CAO in place, strategic planning will come, and then council can together decide what the committee structures look like. We have more staff onboarding to help with capacity, and then we'll get there and iron something out that's productive. So I can answer that one. And yeah, but I'll ask staff to comment on some of the others there.
There's quite a few of them. Here I go. So terms of references for based on a template. So that's correct. Like typically there's the general terms of references that we do use for professional reports, some that are lacking as well that are absent. For the comprehensive development plan areas, though, these are more significant and they look at site-specific features. So to include them in this bylaw specifically, as the gentleman was asking, it would not be an appropriate place for them, in my opinion. So like public information meetings, for example, terms of reference, the more internal documents that we would share with applicants does provide some more clarity. So granted, that's true, but there are some site-specific features that essentially would be considered at the time of looking at these large tracts of undeveloped land proposals. And they come in advance of an application. I'm not sure if council's familiar with CDPs. This is a new term, I think, in our bylaw that we're using, but they're looking at kind of more the larger comprehensive type of developments that essentially look at high level feasibility with professional reporting, like traffic impact assessments, servicing agreements, et cetera. And sometimes they can be phased as well. And then that kind of runs in concurrently with OCP amendments. So at the end of that entire process, after council reviews the terms of reference, before the applicant gets the marching orders to go forward and conduct all these studies, which is approved by council in the procedures bylaw, then we would bring forward land use amendments, essentially. So OCP amendments to these CD areas that we identified in the OCP. Anyway, it's probably not appropriate for them to be living in this bylaw. Anyway, I'll jump to the next one. The timeline for 30 days of denial. So yeah, there's no established target on coming back to council after that application is submitted for an appeal, essentially, of a decision. 30 days, again, doesn't leave us much time to get on an agenda necessarily for council. So I think it might be a bit challenging. Good to have the flexibility to come to council within 30 days or 45, what have you, whenever the agenda provides for it. We could have targets, and we do have targets in our current manuals right now for development applications. These are wide ranging. Like a most common question we get from developers is, how long is this development permit going to take, or how long is rezoning going to take? And it's really impossible to answer that question because there are many variables and we haven't reviewed all the information yet. So they can range from 4 months to 12, or sometimes a year and a half. It really depends. A lot of times when the ball is in the court of the applicant and we're not getting information that we have requested. So that can happen at times, unfortunately. We can certainly look at establishing a wide range of targets within our manuals for something like an appeal process, as noted. Let's see. Cutoff between council meetings. That's interesting. Without a public hearing, essentially. I'm not sure if new information can be provided. I think new information can be provided at any point along that process. A legal opinion may be ideal, but new information coming after, say, third reading could be feasible. But you're right, without a public hearing, essentially, I'm not sure how to address that question from the gentleman, unfortunately. Or you can, yeah.
Thank you. Through the mayor to council. Just to provide some context for this, as many of us are aware, after there has been a public hearing, staff are not allowed to circulate new information for council's consideration and to proceed with the adoption of the bylaw. The spirit of the intent is that everyone who attends a public hearing gets to participate and also hear all of the other participants within the public hearing. And then once it is closed for discussion, and a summary report comes to council for consideration of the adoption of the bylaw. So the intent on closing new information to come into council is, in my perspective, varied, including the lost opportunity of members of the public to hear information related to the issue, as well as information being provided that may be weighted differently. If someone came and had an individual response to council outside of the public hearing process, it may be weighted differently in your decision-making factor. All this to say, staff are not allowed to circulate any new information after a public hearing has closed. With the new regulations for files that are not subject to public hearing, staff do not have that requirement. So the requirement to not circulate new information is not imposed upon staff. So staff would be free to circulate information to council. Council may want to consider any policy approaches just to be consistent to not receive any information after third hearing, but there's not that imposed requirement on staff at this time.
So that's not been included in the legislation then? Because yeah, that's where I remember, like, you shut the public, they have this whole statement and then nothing else can be received. But if we can't have the public hearing, then it's just not the same.
That's
So we
correct.
would
My,
need-
my
would need
understanding
something.
is that that facet has not been regulated by the province, and that council could treat it similarly to other bylaws not subject to public hearing, where information flows freely up until the point of adoption.
Okay, Councillor St. Pierre.
So is this a situation where we would need to publicize that information flows freely up until point of adoption, or we just assume everyone knows what the status quo is? Just
We would need to create a policy.
in terms of responding to Mr. McNaughton's.
Yeah,
Because it's a reasonable sort of thought that everyone needs a level playing field.
it is. So I think that's another takeaway that we would need to address at a later time outside of this.
Yeah, I think it would be, through the chair, I think it'd be unreasonable or unusual, sorry, to be requesting new information after third reading. If there was something that we're hung up on, or council was hung up on during a council deliberation, we could obviously stratify those readings. So you'd have first and second reading, request more information. Then we would come back to council for consideration of third reading or adoption, for example. So it would be unusual, I think, for us to ask for new information after third reading, for example.
Well, it would be, because typically when bylaws come forward for adoption, like, the debate is over, we're adopting the bylaw. So it should, I think that point needs to be made clear, that we have that clear, that it's up to third reading. Yeah, okay.
And
Go ahead.
yeah, there's a couple more here. So 6 months of inactivity. So this would be closing of a file. So we would notify the applicant of the inactivity and that the file would be closed. So there's certainly opportunity for extensions, you know, if for whatever reason they need more time, that we could certainly entertain that.
The other one was, in the event that the density is not as high, then, and it's lower than what is allowed, then that does not need to, it doesn't matter. It's like you can have 1, 2, up to 4. And they're all the same.
Yeah, so this is new to us as well, but the way that we would proceed here would be through rezoning, be looking at the parcel area, and then looking at the maximum density. And in most cases, you're looking at rezonings to a multifamily zone, say RM2 in the community residential land use designation that supports up to 50 units per hectare. Most likely, it's going to require a public information meeting. Where you're rezoning to, say, a new SMU zone that permits small scale multi-unit housing, which we don't have yet. Then maybe there may be cases where the lot size is small enough for not to accommodate more than four units. So we would determine at that time, looking at the parcel area, to have a covenant on the property, we can't unreasonably limit SHMU housing. But when it comes to an RM2 zone, then I guess we could look at covenanting to avoid public information meetings, but I think that would be highly unusual as well. Usually developers looking to maximize the developability of parcels and the density. So I don't see that happening.
Okay. There was allowing staff to approve with conditions, I wrote down. Can you speak a bit about that?
Sorry, yes. So the procedures bylaw does include provisions for taking securities. So that would be kind of the main condition with development permits, like landscape agreements, for example. So we could impose those through the procedures bylaw as drafted. Otherwise, DPs generally wouldn't have conditions associated with them unless it was directly related to the actual development permit that was required. But I'd have to look back in the bylaw itself to see if there would be that ability, and if not, and required and recommended by our consultant, we can certainly consider adding it in and bring it back to council before readings.
Councillor Bateman?
Yeah, so, and I think the final one related to the Development Review Committee, which I believe is not, it's not an externally appointed committee. It is, as the definition states, a group of District of Sooke staff responsible for review of development applications. So that by definition doesn't require terms of reference, but certainly operational practices.
Yeah, through the chair, it wouldn't require terms of reference, but it certainly wouldn't hurt. And maybe Mr. Blewett could speak to the terms of reference, as he's been on that committee for longer than I have.
Through the chair, that committee was formed roughly in 2021 as a result of staff working somewhat in silos. That sounds like a harsh term, but really it was to create context and continuity between a review. So essentially referrals were being provided to different divisions and departments, and there wasn't a discussion with staff around the actual proposal. So this development review committee was formed, DRC, as a means of just getting everyone on the same page to understand what everyone's individual concerns are within their departments. There's a lot of new staff that were on board at the time. A lot of people didn't understand, like, what is engineering specifically looking at, what is subdivision land development looking at, planning, and so on. So it was really a way of just bringing staff together to actually have a fulsome discussion around the development application. It's not so much, decisions aren't necessarily being made in that particular group. It's just basically reviewing a proposal, making sure we're on the same page. And then as everyone goes forward to the reviews, there's better context. That's really what that group is for. But certainly in terms of reference, no harm in having something like that.
Okay, follow up?
Yes.
Sorry, I think Councillor.
Yeah, so I was just going to make a comment how much I appreciate this new, compared to the old bare bones bylaw that we've been working under. Here, each of these schedules gives a very clear line of practice. So starting with that single point of contact, the planning and development administrator, then works with municipal planners, goes to this review committee. So step by step, it seems to address many of the shortfalls identified by the province and the reason for all of this practice. End of comment.
Okay, Councillor St. Pierre.
I just want to return briefly to the, if an applicant wants something to come to council, there was a 30-day for them to actually put in an application or to make that happen. There were concerns around, whether or not we put a specific timeline, but I think what we've done regularly in council is the next meeting or next available meeting. We could even go to any of the next 2 available meetings. But I think that that would provide a lot of, comfort for the applicants that if they have a concern, it'll be brought to council in an expeditious manner. And I would like to see that kind of language included.
I think it's more best efforts. And I say that because we don't meet in August. So if this, and that's where it's just recognizing then that getting a meeting outside of what's scheduled isn't easy. So like just commit that we'd meet in 30 days and we don't have a quorum. Not going to happen.
And having said that, I'm aware that this may be a problem, given that if you have a huge file that's going to have massive complexities, and all of a sudden you're on the hook to get it put together for the next council. Please, staff, have a look at this, but some kind of certainty so that the public knows that it'll come forward in a timely manner. But I'm just putting that forward.
Okay, so where we're at now is to go through the recommendations. I'm following my everything, right? Okay, all right. So we'll start with the easy one. And that is that the Committee of the Whole received the staff report development procedures bylaw regarding implementation of the development approvals process review project for information. Moved by Councillor Pearson. All those in favor? And none opposed. That's unanimous. Thank you. And then I'll read out the header, and then I think we need to break this down into bullets, but I don't want to keep repeating the header. And that would be that, and that the Committee of the Whole recommend that council direct staff to amend the development procedures bylaw in accordance with the following. So we'll start with section 1, notice of application signs. That a notice of application sign must be posted by the applicant at their cost in accordance with Schedule 1 of the draft bylaw, attachment 1, for the following applications: OCP amendments and zoning bylaw amendments. It's moved by Councillor St. Pierre. So we don't require a seconder. Would you like to speak to this? No. Anyone else like to comment? Okay, I'll call the question then. All those in favor, please. Any opposed? Nope. So that's carried unanimously. Okay. So the next one is public information meetings. That as outlined in the schedules to the draft bylaw, an applicant for OCP and zoning bylaw amendments are subject to facilitation of a public information meeting in accordance with the following. So these I'm going to do one at a time. So the first bullet would be applications proposing residential development with 5 dwelling units or more are required to hold a public information meeting. Moved by Councillor St. Pierre. Would you like to comment? No. Anyone else? Okay, I'll call the question. All those in favor then? Any opposed? None opposed. That carries unanimously. The next one is applications proposing residential development with 4 dwelling units or less are encouraged to hold a public information meeting. Moved by Councillor St. Pierre. Would you like to comment? Into the microphone.
Oh, that's right. Yeah, no. I think that the public, that applicants should be encouraged to hold these meetings, that they can actually help their process, make sure the neighbors are on board, allay fears of the neighbors. The fact that it's encouraged and not actually required is good.
Okay, Councillor Beddoes.
Yeah, I disagree. I would like to see that to be required as well, so I will not be voting for that.
Councillor Pearson.
I don't like the word encouraged. I think either you do it or you don't, and I would think for 4 lots less, if it's a parent property, and 3 lots, I think it's going to be part of the neighborhood. It's going to be filled in. It's consistent with what the province is asking us to do. I would be more in favor of removing it. I will vote against it in its current format.
Other comments? So I wrote down required ? Instead of encouraged. So because we're encouraging to have the meeting and they come forward. No, we didn't have one. So now what? So I agree. We either require it or we don't. It's one or the other, I think. Councillor St. Pierre.
If that would be the case, I'd be more in favor of requiring it than actually doing away with it entirely.
Okay, then I would suggest you amend the motion.
So I would like to amend the motion to are required to hold a public information meeting.
So strike out encouraged and make it required. So that is the amendment that's on the table now. So on the amendment to switch from encouraged to required. Councillor Bateman, can you just turn off your microphone? Oh, thank you.
So my comment here, we had encouraged because we were respecting these mom and pop, quote unquote, applicants who are new at this game. And I think we've heard today that the district will assist in some way to create materials that will allow them to proceed with some kind of public information hearing meeting. So just through you to staff, that was in fact, was I correct in that you will be creating these materials to assist?
Through the chair, yeah, we do have a general terms of reference for requirements that would be part of that public information meeting. Yeah, but in this case, we were talking about potentially small lots being rezoned, maybe for single family dwelling use, 1 or 2 properties could be subdivided potentially. So this could be very small scale. And council may want to consider just maybe this being an onerous endeavor for this small scale type of development.
Councillor Pearson.
Yeah, I think we hear a lot about the 1-lot subdivisions and things like that. I just think this is another level of bureaucracy that you're infilling in larger pieces of property. I 100% support it for 5 and more. I understand it. It just feels like another onerous thing that we're adding in there that we don't really have to.
Okay, Councillor Beddoes.
Yeah, I disagree. I think what I like is democracy, and I like the public to be informed. And I know it might be a little bit of an onerous thing for even splitting a lot, but I've seen how contentious splitting a lot in 2 is. So I'd like it a requirement, and everybody's on the same playing field. The neighbors know what's going on. So I'm okay with the amendment. I think that's necessary. 4 or 5 lots doesn't matter to me. It's a change in the neighborhood, and it should be out in the public, for the public notice.
Okay, anyone else? Now's the chance to speak. Councillor Lajeunesse, is that a hand up or?
Sort of, yeah, I guess, could the signage provide enough information for people on a smaller scale development?
Maybe, maybe not. You read a sign though, you have questions. So then how do you have those questions answered? You don't. The sign doesn't speak. It's
A
an
phone
inanimate
number at
object,
the bottom.
if it's there. Councillor St. Pierre?
I tend to agree with everyone, honestly, which is problematic. But having said that, I think that if someone is in a neighborhood, and if they're just brand new in the neighborhood, it's a good chance to meet the neighbors. And if they know everyone already, it shouldn't be too hard to do, ideally. And I agree with Councillor Beddoes that you can have a lot of contention in the neighborhood that doesn't have to exist if there's decent communication. It's a pain in the ass, but at the same time, it may actually be the shortest way to get there. So
I'm in support of the amendment because it is the information. You're changing a neighborhood. So it could be a vacant lot right now that everyone's enjoyed for various reasons. And now there's going to be 4 units on it. And where did that happen? So sometimes it's that share of information, and you could otherwise end up have all sorts of issues as projects unfold, complaints around construction noise and trucks and all of these things, and the tree damage and all those things that were then everyone in the neighborhood is reacting to after the fact. Why didn't we know this was going on? You've changed my neighborhood. So in the absence of our ability to hold public hearings, and I appreciate it could be smaller operators, but maybe not. We don't know. So it's I'm just in support of it for all those reasons. So I'll call the question on the amendment. This is a changing from encouraged to required. All those in favor, please. Any opposed? Councillor Pearson and Lajeunesse are opposed, so that carries with myself in favor. So now on the main amended motion, which would be applications proposing residential development with 4 dwelling units or less are required to hold a public information meeting. All those in favor? And opposed again on the main is Councillor Pearson. Okay, the rest are in favor. Next up is applications proposing all other types of development may be encouraged or required to hold a public information at the request of council and or district staff. So on this one, I suggest that we need to decide encourage or required. And council and or district staff, I think is fine, but it's one or the other. I haven't moved anything, so you can ask whatever question you like.
I think that this feels a little bit loosey-goosey right now. So all of the types of development, I don't know what that is exactly, so that's a bit of a problem. In terms of voting on the motion. I like actually the encouragement required because in this particular case, again, I see the encouragement more as one of those valid reasons where we're giving staff the latitude to not require in situations where it might be onerous, as Councillor Pearson has pointed out. And I tend to agree, but I don't know exactly what this means with all other types of development. So through your worship to staff, if I get some clarity on that.
Yeah, so these would be through the chair in the case of commercial zones, commercial industrial zones.
So residential to commercial or just anything, because it's all others.
Yeah, so this is limited to zoning or OCP amendments. Right, so in that case, you're looking at zones outside of purely residential.
Councillor Beddoes?
Yeah, I think the fact that you got the word may in there says it all. Application proposing all their types of development may. So you could take out encourage, may be required, but it's up to staff or council. So I mean, encourage is kind of redundant when you always say may. I mean, you may encourage them or I just say may be required to.
So that sounds like emotions. We're going to move that
Sure, I'll
along.
make that. Applications for all types of development may be required to hold a public information request of council and or district staff.
Okay, that's moved. Would you like to comment to it?
No, I think I did. I think that that cleans it up pretty good. It gives us the option of having it. It's just yes or no. I don't see a point of just encouraging to do it. It's again, some will, some won't. But I think that's clear. If it's something minor, then staff will say it's not needed and it's a may. So it's good.
Okay, anything else, Councillor St. Pierre? On the motion in the mic.
I would support this, but I was hoping for some clarity from staff on twice now in this particular suite of motions, the word encouraged was used. What was the rationale? Is it okay to ask that or?
Yes.
Yeah, through the chair, encourage, I guess, to not be so prescriptive, to consider it, I guess, a bonus type of engagement session that could be, the results could be presented to council if determined to be required, or if we were anticipating maybe some contention with the neighborhood.
Would there be anything in terms of, for example, staff manuals that would stop you from encouraging applicants to do this anyway? Would the results not be reportable to council? Would you not have the option of encouraging an applicant unless we specifically say this? Or if the language is not here?
Through the chair, I suppose so. We could not encourage.
Well, you couldn't. What I'm asking
Yeah.
is, could you encourage without direction from council?
Yes. No.
Councillor Beddoes?
Yeah, I think the public and developers, they want things in black and white. It's yes or no, or when you go to encourage, it can be all sorts of things. You're rah on the street corner, or you sort of, wink, wink. If you encourage to do this, I don't like that. It's either you do or you don't. And this one, we do have the ability to push it if we want. If it's minor, then we can let it go. So I like the way my amendment states it, and it makes it clear for everybody.
Yep, works for me. Okay, I'll call the question. All those in favor? Any opposed? Councillor Pearson is opposed. That motion carries. Item 3. And that the applicant is required to facilitate a public information in accordance with meeting guidelines provided by district staff. Moved by Councillor Bateman. Would you like to comment? Into the microphone.
Yeah, I don't need to comment.
Would anyone else like to comment? Nope. Call the question then. All those in favor? Any opposed? That's carried unanimously. Okay, item 4, delegation of authority development permits. The header reads that council delegates the authority to issue or amend development permits to the Director of Planning and Development for the following. So we'll do this in pieces again. Item 1, small scale multi-unit residential developments that do not exceed 4 units outside the town center as defined in the official community plan. Would someone like to move that? Okay, Councillor St. Pierre has moved that. So this is to delegate authority for small scale multi-unit, not over 4 outside the town center. It's defined in the OCP. Councillor St. Pierre's moved it. Would anyone else like to comment? You would like to motivate further? Into the microphone.
Whoa. I think this is the direction that the province has taken us, and I think it's scary. And I think there's a fear attached to losing power and this encroachment on our authority by the province. But at the same time, we also have responsibility to the development community and to the whole process that we've undergone at a cost of $500,000 and who knows how many staff hours and so on and so forth to actually improve our development process and make it more responsive. I think this will help in terms of doing that work. Other local governments are moving back in this direction, are moving in this type of direction. It's not something that's unknown. We're not doing anything that scary. I think that at the end of the day, we can also take back any power that we give. This is actually our power, as opposed to the province telling us, you know, you must do this thing. This is something that if we determine is not right, we can do something about it. But in the meanwhile, I think we do have some good reports, some good work from staff in terms of how to actually streamline, and this is the direction that's recommended.
Councillor Beddoes.
Yeah, I'm a little uneasy about it as well, but again, that's just my feeling about what the province is doing to us, but it colors it. But I think the safeguard there as defined in the official community plan, so the onus is on us when we get this official community plan modified or whatever we're doing to it, be very, very careful in what it says and to make sure that the public weighs in on it. Because once it's in there, it makes it a lot easier. So I'll be okay with this motion with a little bit of trepidation. Okay. No.
I'm not in favor of this. And I'll leave that. It's outside the town center. Typically, we want to see more density in the town center, access to services, walkability, all those things. This is all outside of that. So that's where I feel that council needs to weigh in on the impact, and the community should have impact and have some say on how those more not rural, but more suburban places are changing character. Councillor Beddoes?
Yeah, just a little clarification. I thought when we did these units that they had to be close to a bus line and sewer and all that sort of stuff. Does that still apply to these?
Well, you got me there. That's why with it all being new, I'd like to rather see it come before us and weigh in as opposed to it's built, it's done, and now we're trying to fix it and we can't because it's over.
So with that, I'm changing a little bit because my understanding was that a lot of the more rural areas of Sooke were protected because we don't have bus service. Oh, we have shitty bus. I mean, not inadequate bus service. Sorry, apology there. It was strike that. So I have changed my mind on this one, and I think that this is a little premature. I think I would like to see a little bit more. If it doesn't, those are the restrictions that I heard. And that we wouldn't be bugged by the province if they, if they were in these areas not serviced. So why are we pushing this in an area that isn't serviced by bus? Some of it's sewer, I suspect. But the whole idea of that density is that they use public transit, which is pretty pitiful at best. So I won't be supporting this.
Councillor Bateman?
Well, I think the SHMU legislation does very clearly indicate that this kind of multiplex is only to happen when water and sewer is available. And also I'm thinking back to our,
No,
there's the transportation oriented development, which allows the larger high rises, and Sooke has no such areas. And also back to the pending official community plan and the development permit guidelines and exemptions. I think you are exempt from needing a development permit if you are building less than 4 units on your subdivided waterfront property. So yeah, I think if council retains authority, our agendas are going to be so packed that as infill begins to pick up pace.
or
So
they
I
won't
don't know.
be, because then we'll get the feedback in terms of what's working. Like we're putting through a lot of changes. So, and there's been, a lot coming down from the province, but we still need to grow and recognize our village, our vision for a community in accordance to what Sooke wants, not what the province is dictating to us. So I think, let's get through all of these things and address our OCP, and then we have the opportunity to delegate it in the future. This isn't finite, but for now, if I saw something, I'm like, okay, now I get how this works, as opposed to some small diagram. Thank you, Councillor Lajeunesse, that says that just has like a cut and paste from somewhere. Here's where we can actually see it in live form, from a planning stage to an approval phase to it breaking ground and so forth. Okay, this is what they're trying to see. But once it's built, it's there and we can't change it. So that's where I'm like, we can always delegate this at a later date. Councillor St. Pierre.
I think it's really important to remember that the Director of Planning is actually our staff, and under the direction of our CEO, who is our staff. These are not rogue elements doing whatever they want in our community. They're actually people that are under the direction of council. We can actually have policies and direction that we give to our CAO. That will go to our Director of Planning. We should be able to get what we want out of the OCP. We should be able for our staff to understand what council is looking for. It's not for us to do necessarily staff's job. What we need to do is to have a good communication with staff so that staff knows what we want and is actually making that happen. So I think it's about building a relationship of trust with staff in terms of making what we want to see happen. As opposed to, I think what I'm hearing is very much, there's a fear that because the province is actually trying to take literally our power away, that we have to hang on to it. I would suggest that if we can provide the results that are needed within the spirit of legislation, then we won't necessarily have to have the province come back with further legislation, further restricting our powers, which is actually something I'm concerned about here. If we decide that we're going to actually go through every single application, and if we have a huge amount of infill and our agendas get packed, as Councillor Baton is saying, applicants are waiting 6 months to a year or 2 years for a permit, there's no way the province is going to put up with this. I think we need to make this work the best way possible. I don't think it's necessarily by going through every application ourselves. I think we get good staff, we make sure we give them good direction, and we let them do what we've asked them to do.
And I don't disagree with you. I feel that they will do that, just as they always have been, in a much more complicated type of scenario with tremendous pressure. So that's where I think over time we can see this. But I think when council hits the strategic planning, we have a time now to be like, okay, where are we going to focus? Are we just going to allow all, is that our focus? Small builds all over the place, or we actually want to, prioritize the town center and focus on the commercial, economic, and all of those pieces and the density where it's sited, as opposed to clearing more areas in the rural because it's quicker and faster. I don't know. We haven't had that opportunity to come together and discuss that. And so once those things are set, maybe we have a committee in place, things will maybe start to roll sooner. But to me, it's too early. I'm not handing this over. I'm not in support of it. Councillor Beddoes.
Yeah, I'm inclined to agree with you. It's far too early. I mean, when we get through our official community plan for second, third, fourth time, whatever it is, and have a little clearer picture, but I guess for me is my 6 years being here is I've seen some proposals for some developments like 4 units on a lot did not fit with the neighborhood. And I think the official community plan was too vague. So I'm not prepared to see that outside the downtown core where we and the community said, and that's what I go back to because I worked on that. The community wanted to develop in these areas, and they were very specific on those areas that they wanted to see the higher density. And 4 units on a lot to me can be higher density. So I just not in favor of this at this time. Farther down the line, I agree. When we get more information, then we go for it. But right now, I can't say. Right now, it's a bit too fast for me.
Okay, I'm going, are you going to speak? Okay.
Wanted through you to staff. What are the implications of us denying this?
Well, currently, outside of the town center, all residential development is delegated. So I think the implications, again, this is form and character only, right? So this is not a question of land use or rezoning. This is form and character of a triplex or of a fourplex, right? So just want to be clear on that. But the implications would be a significant amount more paperwork for staff and a significant amount more presentations, reports to council. So, and also likely pushing other files to the sides in order to bring these forward to council. So certainly an issue on staff capacity.
Okay, go ahead.
Just to follow up, something I learned early on when I started this job is that we don't always have the prerogative to actually deny a development permit. These permits, would we be in a situation where we can easily deny them or deny them at all?
Yeah, through the chair, it would be very challenging, I think, to deny a development permit for form and character for a fourplex, for example. Yes.
So just to confirm, we're looking at additional paperwork, additional staff time. We don't necessarily have the ability to refuse anyway. This is make work. This is not power that we're holding on to. This is make work we're holding on to.
Okay, I'll call a question. Sorry, you wanted to speak in?
I just wanted to make the comment that the province is about, in due course, will release this catalog of building types, which apparently are pre-zoned and ready to roll. So those, I'm just saying that. I don't know why I'm saying that, but it's
good to know.
Change the game, consider it.
Well, then they're going to change the game for us yet again. Okay. All right, I'll call the question. All those in favor? And opposed? Oh, it's defeated. It's tied. So Tate, Beddoes, and Pearson are opposed. So that's a tie vote, which means that fails. So it, there's no change, I guess. Multifamily residential developments outside the town center is defined in the official community plan. Is the next one. Question of staff?
Curious, is this another one of those things where if it's gone through, we can't easily say no to it? Are all of them like that? Because I'm pretty sure they are.
Yeah, so through the chair, again, yeah, if we're looking at development permit for form and character, for example, we're looking at the guidelines associated with form and character of the building and structure itself. It would be challenging, yes, if it'd be a hard argument if they weren't meeting the guidelines, but it's certainly possible. Unlikely.
Thank you very much. And that's for all the remaining.
Yeah.
Yeah.
And our current procedures does allow staff to, delegation of approval for these multifamily developments outside of the town center. I think the rationale around that is essentially the town center is where the highest density and most potential for contentious applications exist. Yet on the outskirts where there's lesser density and where they're aligned with the guidelines, no variances are being proposed unless minor, of course, this draft, then they could be approved by delegated authority.
Thank you.
Okay. I would review this when the official community plan is adopted. So multifamily residential developments outside the town centers defined in the official community plan. Was that moved by Councillor St. Pierre? Okay. I'll call the question then. Okay, motivate.
Okay, so in this particular case, the province has made it very clear that they want these types of developments happening so they can actually have more housing. Waiting for the official community plan, which could take 6 months, a year, who knows? And then for everything else to fall into place, we're essentially could be considered to be obstructing. I don't know how that would fall out. Okay. I don't think I'm comfortable with this because that's what it feels like exactly. And people do need an efficient way of actually building. Our developers, our builders need to be able to actually get the permits out. This is actively making it harder. It's putting, people are going to ask, why do we need more staff? Well, we need more staff because council has decided to go through every application. It's like, what are we doing here? We're going to spend more taxpayer money, more of our time. This is not the direction we need to be going at this point in time, I believe. I'd like council to please reconsider.
Well, we haven't voted yet,
No,
so,
but it's,
okay, other speakers, Councillor Pearson.
My problem is not the concept, it's the lack of the OCP in the background. And we're forging ahead with making decisions without the OCP. We have an existing OCP. So if it's inconsistent, my challenge is now that I'm looking at development outside the town center, which we promised that's what we would do. Our OCP hasn't, it may have some identified areas in there, but I don't know what that is right now. And I'm struggling with it. I get what you're saying. I get the concept of where we're at, but it feels like we're kind of charging down the road, but we don't have all, like we don't have all the tires on the car yet or something.
that's just a very good question. I would actually want some clarification from staff on this. Right now, we have an existing OCP. In terms of the draft OCP, what kind of changes would we like to look like with reference to, this thing that the province is doing with 4 houses? Will a new OCP make a difference? Because if we're waiting for an OCP that's not going to make any difference anyway, I don't know why we're waiting.
Councillor Beddoes?
Yeah, having worked on whatever it is that we're coming forward on the OCP, we looked at that question, and that's why we have those 2 zones, and the heavy one downtown, which is in red, and then you have a pink zone, which is sort of an infill on thing. We looked at that question, and what we had from the community is they were happy with that. They wanted the rural parts of Sooke to remain rural, and that all the building was supposed to be in the downtown center. And this other buffer zone is the heavy one, and then the minor ones. So again, it's unfortunate that we don't have that. If we had that official community plan, it spelled it out pretty clear where these things could go. So we're working on the old plan, which is outdated. It is going to be changed. So it's just frustrating to me because I don't want to screw staff around. I want them to have the flexibility. They're intelligent people, but that it's just that OCP that is holding us up. So I don't know. Again, we can change it anytime, but I'm not sure where to go on this. Are we going to put some roadblocks up, as Councillor St. Pierre says? Am I just digging in because I'm a little annoyed with people, or well, I am, but I mean, I also have to look past that and see what's best for the community. And the community needs an official community plan to make these decisions. It's really tough.
I'd like to get that question answered by staff, because right now I think we have zoning in place for those out of town center areas. Is the draft OCP or the intention to make it more permissive? Are we planning on down zoning? Because my sense is that we're not planning on down zoning, which means that whatever is going on is already permitted, specifically in out of town center. And that's what we're talking about here.
Is there any comment from
The
staff
upzoning might
back?
allow more, but it's not going to allow less. So
Yeah, through the chair, Councillor St. Pierre is correct. So the community residential land use designation, which is the buffer area you're referring to outside of the town center, currently permits up to 50 units per hectare in a range of uses, multifamily, apartment, townhouse, etc. In the draft OCP, It's currently drafted for 70 units per hectare. So it would be increasing, that buffer area would be increasing its density potential and allowing for a variety of multifamily uses.
So essentially, if we were to move forward with this, people might have the right to use exactly the OCP we have right now with the zoning that exists and would have less density than they will when a new OCP comes into place, potentially if the OCP is ratified as it is in the draft. We're not really, the weighting doesn't actually change the game. Well, it does change the game, but not, other than adding work for staff, work for us, and if we want to, you know, give the province a black eye, we're not actually doing our jobs here.
Okay.
So just another note is that the areas outside of the community residential are rural residential, for example, and limited in their density and developability potential. They'd have to be serviced, of course, as well. So our zoning regulations currently address that as well with parcel area and what you can currently construct on parcels zoned in or have with land uses in those areas beyond community residential and even within the community residential area.
Okay, Councillor Bateman.
Yeah, I'm just looking back at the current delegated authority guidelines, and it looks like we're taking back a lot of power here, from what we're seeing. And as much as I appreciate staff's presentation today, we're also missing our director of planning, who ironically enough, I think arrives in a couple of days and or next week.
June.
Okay, June. Nonetheless, he will have some thoughts on this too. So I guess you're right. Everything it can be amended and revised in due course. And hopefully we would make that revision very quickly, for example, with the what we've just defeated.
But that's not clear to me. So in the case where you've raised that, Councillor Bateman, it's like, okay, if you went back through the minutes, you'll probably find that I voted in opposition to those things. So it's probably, I'm being consistent, if anything here, but that's not clear to me in this report. So I'm going with what we heard and what's in front of us and the new reality that is coming down from the province. So it is what it is. I just know that our roads are busy. We have one bridge under the province's jurisdiction. We have overcrowded schools, all provincial jurisdiction. And now finally today, we've managed to get traction with healthcare, something I've been working on for over a decade. All provincial responsibilities, no after-school childcare, shortage of infant and child, all in the provincial health. And as you know, we've been doing tremendous work to help those that are unhoused in our community and certainly relying on the goodness of volunteers and other contributors for all of that. So there's a lot to hand back to the province if that was the case, where they're upset that we're being obstruction because we're downloaded and our hands are full with other stuff they should be dealing with. But in the meantime, we're trying to control the destiny of our town and to have the public who are increasingly frustrated and upset with traffic and everything else wanting to know what's going on in their neighborhoods. So that's why I'm not comfortable abdicating our responsibility. If it means that we have to meet more often, so fine. If we have to meet past 11, but we all have the opportunity to share the air and to be succinct in what we say and what we come to do. That's upon all of us here together. But meanwhile, we're in a process. And like I said, and I'm just going through my time here in this chair or in this chambers. We handed delegated authority to staff. A big problem arises. And then there's just upset, and then we're reacting and trying to fix it after the fact. Whereas maybe if we see how things roll out, to be like, okay, this is rolling well. You know, we have 10 applications coming in one meeting. We're adjourning to go to another meeting. It's like, okay, we need to hand this back to staff and this is okay because it's rolling forward. You know, earlier today, a representative of the Sooke Builders Association, even though the other person disagreed, shared that there was frustration there. And I neither agree nor disagree with this, but I've seen some really bad behavior downstairs. And it's awkward. And then we're trying to fix it after that, not from our staff, but unfortunately from people that are not upset, that are very upset with the position that our staff have taken in doing the work we want them to do. So let's take that heat up here where it belongs. And when our new director onboards, we get strategic planning, then it's like, okay, these are the things that are rolling here. We understand what this looks like and it can go back, no problem. I don't have a problem with that, but it's here in front of us in terms of taking power back. It's not because I don't trust our staff. I fully have the whole way through. But this is what's in front of us here. And then we're seeing consolidation in a number of different pieces. And I have no problem reviewing it off into the future. Not at all. But let's just see that it's all rolling as it should be so that we're not fixing it after the fact. And our community has been silenced through the provincial legislation. I just feel they have any opportunity that remains with how their neighborhoods have changed. They need an opportunity to know in a transparent fashion that their views are being looked after. Even if there's nothing, we can do about it. Is just say, the province is making this happen and we have no option. We're trying to make it as best as we can. Councillor St. Pierre?
I just wanted to address the issue of staff and the heat they might be taking. I think part of the heat they're taking is because of delays. Because things take too long. Adding more unnecessary work is not going to make that better. So I really think it's important that we actually move forward with the delegation.
Okay, Councillor Meadows?
Yeah, I think the frustrating part of this is that, this is something that I would like to review in like a strategic plan where staff is in the room and we can discuss that and get their opinion of it as well in sort of a discussion mode as opposed to this. So I just find it extremely frustrating. I don't want to, staff, I think in my 6 years has served us very well. But again, I'm stuck with a community that is growing frustrated with all levels of government, including us, saying, you're the ones that we're paying to make these decisions, and we're not happy with the way the growth is happening. So I don't know, maybe the buck does stop with us, and if it means a little bit more work in the situation, then I guess that's it. But I just so uncomfortable with all of this. I'm so frustrated. I didn't even know where to move on it.
Well, this can be postponed to a future meeting. Can it not? Like, these are the option council has. You can vote on it one way or the other tonight. You can table a motion, you can postpone a motion. Just as your chair, I'm reminding you of your options. But if you are not voting, you're in the affirmative. So, Councillor Lajeunesse. Councillor Lajeunesse is next.
Yeah, I think the frustration that that the mayor speaks of downstairs and in the community is the snail's pace at which approvals take, and staff has identified the reason for that is because they have to prepare reports for council. Everything has to come to council. These are all designed to deal with that, to speed up the process. And I think we're just going to be status quo if we defeat all of these ideas. So,
well, the last one was tied. So, and you voted not to delegate authority. So. Okay, fair enough. Okay, my mistake. All right. Okay. So, Councillor Bateman.
I agree completely. The whole point of this $500,000 review process has been to finally, create the system, as I was trying to explain to Mr. Haldane, that this is a new era of dealing with an issue that's been alive here in Sooke for over a decade. And with this renewed clarity that an applicant can come to us if indeed they're unhappy, then I can see that as the seems to be a really great system as proposed today.
Okay, so I have an idea. Bear with me here. So what I'm not seeing in this report is where we have already delegated authority. Like, to me, I read this as new authority being delegated to staff. I didn't see this as delegated authority that we're taking back. That was a point raised to me by Councillor Bateman. So that's why I'm being difficult. Because I'm not seeing this. If the shoe fits, then fine, you can keep walking in it. But I'm not reading this. Like I didn't hear, like that's where there was a screen from our presenter. And it was difficult to read that table on the screen about before and now, because there's 4 different columns of information. So in some ways, if the authority's delegated and it's working, okay, fine. I looked at this that you want more authority delegated, and that's why I'm being difficult. So, because I want to hold on to what we have. So an answer would be that we're sitting as committee of the whole and it feeds to council. So not to create a make work, but I'm going to do it, that if you feel that this is what you already have, then okay, we would like to retain that delegated authority, and here's what needs to change and what we suggest you give us more of. So I looked at this going, this is all now a decision made by council. So when we hear, oh, there's going to be tons, I'm like, what are you talking about? Because in the last 5 years, I haven't seen any types of long reports, and it's us chattering with each other why we're here till 11, not because of that, right? It's the reports where they're not, the last ones, the meetings went longer because the decisions were not supported, and we had a lot of conversation about that. But I'm not seeing these other ones roll forward to us. So that's where I'm a bit amiss. So in this case, what you could do is take the report and just say, okay, here's what you already have delegated to us. Can you please affirm that we can still retain this? And here's what is new that you want added to us. And maybe that can be a decision that council makes and ratifies it at the next meeting, because this all has to flow to the next meeting anyway. Well, I don't know. I have to unwind myself from everything I've just said in terms of what process wise makes sense. Councillor Beddoes? I'll just go to Councillor Beddoes and then look for.
Yeah, I agree with you. And again, I think it's a lot on the presentation. At the last council meeting, one previous, I asked for a little clarity, and the staff put it, the 2 options side by side. This is what the developer wants. This is what the variance wants, and this is what's required. And it's pretty easy to decide. That's okay. They want, this is what they want changing. So if a lot of this stuff is being handled successfully, and I assume some of it has, maybe we are cutting it a little bit short, because I'm grumpy as hell about it, as you all know. But I do have a great deal of faith in staff. So maybe if we could put it in that context, I'd be more inclined to move some of the things along. Again, they keep throwing out the official community plan, which drives me crazy. So a little clarity might go a long way, or I'm sure staff can, whether they put another bullet underneath in red as this is what we, this is what it said before, and this is what it's saying now, or the same. It's right now I'm having a tough time with it, and I'm running out of steam.
Mr. Riley.
Yeah, so I can confirm here that nothing is changing regarding this section. So the motion's here for delegated authority for those areas outside of the town center. What's being proposed here in the motion, nothing is changing, just an update to the language. So the language for 4 or less. So otherwise status quo to provide, is that clear? Yeah, so motion number 4, I'll just pull it up myself. So this is currently all accurate, currently consistent with our current delegated authority in the current delegated DP delegation bylaw. Number 4.
So number
Except-
4, so for clarity, number 4 in its entirety is what is in place right now. And then the only changes that you've made is the 4 units.
Correct. And that's just to be consistent with the changes upcoming through the province. It's noted in the body of the report that way. So in this section of the report, it's noted, and then also in the slides, and as was presented earlier.
Okay, it's not that clear to me. But that's okay. All right. Okay. So to find a way forward here, so council comments. Counselor Pearson.
Okay, through you to staff, would it be possible, because because we're in committee of the whole, would it be possible to bring, and I'll just use as an example, not for the entire report, that bring, number 4 forward with a line between the dots that says current process, or minor changes to the existing, or for all 4, 5, 6, 7, and 8, I think. Would it be possible to have that presented to us at council? Because I think I understand now that this is our current practice. That's what you're saying, like in your words, Mr. Riley? This is our current practice.
This is
That
current.
was not clear to me throughout the process today.
Yes.
Okay, so.
I'm sorry about that. Yes, it is current process with the slight
Okay.
change in the language in that first bullet.
Okay. How many and where are the changes? Will you be able to track the changes? Let's just say number 5 now. Number 4, it's status quo with maybe some wording changes. Is it possible to get the report at next council meeting that between the bullets, it says, this is a change?
Yes, that's possible.
Is it easy or is it onerous for staff?
That would be easy.
Okay.
I think it gets more challenging as we get into the other elements. I can tell you number 5, completely new.
Completely new.
Completely new.
Well,
Right.
actually, number 5 is the duplication of number 4 on the screen here.
Yes.
So there's a
That's why.
slight mistake.
Sorry, number 6.
Number 6, okay.
Number 5 is the same as number 4. I was just going to ask that question. So, because I'm having, and maybe that's what I'm reading ahead here. It's exactly the same on our screen. Okay, but we're looking at what's on our screen. That's what we're going by.
We can bring up our presentation with the second set of motions. Oh, here they are. Okay, you got it.
No, yeah, okay, that's been fixed here. So I would perhaps suggest that item 4 be referred to the next regular scheduled meeting. Actually, I was going to go to our corporate officer first for the process piece here.
Thanks. Can I get some clarification? Just before I provide my suggestion on how to move forward. We did have a vote on the first part of number 4, and is this intention of council to undo that so that they can consider it again? Okay, so 2 things, and Mr. Pearson, or Councillor Pearson, just 1 second. So what I would do in this case is we have a motion on the floor currently that has been moved. I would look to the mover to withdraw the motion. Thank you very much. And I would also look to council to make a vote to rescind the previous motion that, regarding the small scale multi-use residential developments that do not exceed 4 units. If council wants to consider that with revised information.
Okay, so is there a motion to rescind? So that'll be moved by Councillor Beddoes. Okay, rescinding the previous motion. Okay, all those in favor? And that's carried unanimously. Okay.
Thank you. And then I would be looking for a motion to refer section 4, delegation of authority development permits to the next council meeting for staff with staff clarification on current levels of delegated authority. Something to that effect.
Counselor Pearson is making that motion. So item 4 in its entirety will go to the regular meeting. Okay. And we can get clarity on that. So I'll call those all those in question, please. All those in favor? And that's carried unanimously. So then item 5, this is new. And so that is where, and that the Director of Planning and Development will refer a delegated development permit to council when the proposed delegated development permit meets the criteria to be delegated to staff, but in the opinion of the Director of Planning and Development, it would be in the public interest to instead have the application considered by council, or the proposed delegated development permit is associated with a development variance permit that requires council consideration. So that's one. You're not asking us to choose one or the other. It's both of these. Okay. So that's moved by Councillor Pearson.
That's going to council. To take this to council.
No, number 5 is we're gonna discuss that now. But this is a new piece in terms of where the director could be like, okay, you know what? This needs to come to council and not be resolved by staff. That makes sense. Okay, well, it does to me. You disagree. Okay, that's moved by Councillor Beddoes, or Pearson already moved it. Okay. No, he moved number 5. Okay, all those in favor then? Okay, that's carried unanimously. Now we get into delegation of authority minor variances. And this is new. Completely new. Okay. So I'm going to try to do this all together. That council delegates to the Director of Planning and Development the authority to issue minor development variance permits where minor meets the following criteria. The variance would have no significant negative impact on the use of immediately adjacent or nearby properties. Degree or scope of the variance relative to the regulation from which a variance is sought is not significant. The proposed variance is consistent with the general purpose and intent of the zone, and there is a valid reason for the variance request. It's moved by Councillor Beddoes. Would you like to speak to it, Councillor Beddoes?
No, I think this is exactly what we've said in the past, is that some of these smaller things do not need to come to us. And I think it spells it out pretty clear here. So staff can figure those ones out pretty quick.
Okay,
And that will streamline things tremendously.
Councillor Pearson.
I'm in support of the motion with the exception of the last bullet. There is a valid reason for the variance. It's a valid reason. Who decides what a valid reason is?
That's in the microphone.
Yes, exactly. I have questions when it's an ambiguous statement like this. There is a valid reason. What is the valid reason? What's the criteria? No terms of reference. So I would support the motion in general, except for that.
Okay, how about we sever the motion then? I'm going to sever that as chair. Well, he'll vote against it. It's all together. Okay, fine. Go ahead, Councillor Bateman. Okay. Well, we're moving along. We still have
I
quorum,
just note
so
that the rationales for these criteria are in the bylaw. So it's not a mystery what these valid reasons would be, if I've read that bylaw correctly.
okay, the valid reasons are in the bylaw. Anything count?
Oh, sorry. Wrong thing, wrong finger.
Handing me the wrong finger there, but that's okay.
I was just gonna, as the mover, I was just gonna say, I don't have any problem with that bullet.
Okay, Councillor St. Pierre. Go ahead, Councillor Lajeunesse.
No, I think the consultant mentioned this earlier today, that a valid reason would be if a foundation were poured 2 centimeters closer to the property line, or something like minor things such as that. So
Councillor St. Pierre.
That was actually a concern that I had initially, and we discussed it a little bit further. I really like the valid reason because it gives staff the discretion to do the common sense things that should be permissible.
But it's
That's
all
when they
in
come
the
to us.
bylaw.
That's when they can come to us automatically. Automatically, if they don't like what they hear, they can come to us. But meanwhile, if they give a good reason that makes sense,
to the director of planning, they can move forward with the application. Everybody's happy.
So
And
like
that-
if, we just heard an example of a foundation poured 2 inches off of where it's supposed to be. 2 centimeters.
2 centimeters.
It's even less. But that's what it's, as Councillor Bateman prescribed, noted, it's fully written out in the bylaw for the valid rationale with the descriptors. Okay, anyway, I'll call the question on this one. All those in favor, please. Any opposed? None opposed. That carries unanimously. Okay, number 7. That in deciding whether to issue a minor DVP, development variance permit. The acronyms, okay. The Director of Planning and Development must consider the following. The variance addresses physical or legal constraints associated with the site, example, unusual parcel shape, topographical features, statutory right-of-way. There is a community or environmental benefit to the larger community and or it would support a council priority, affordable housing, environmental protection, provision of a trail, statutory right-of-way. Must not include a reduction in the required number of parking stalls, except in situations where an increase in parking spaces is associated with a change in use associated with a business license application and does not propose additional floor area. Proximity and impact of the variance to neighboring properties, impacts to the character of the streetscape or surrounding neighborhood, and if strict compliance with the zoning regulation would be unreasonable. That's the line I still don't understand at all. It seems to be a catch-all, but there was no real valid reason given for that one. Councillor St. Pierre.
Move, but I also have a question for staff.
Moving it with the question.
Moving with the question. So, does staff already have any of this delegated authority? I know number 5 was all brand new. Is this all brand new as well?
Brand new.
Brand new. Good. Just want to confirm that. Don't want to. Sorry. Don't want to get caught the same way twice. It's just, in terms of the where is it? The unreasonable. Again, a small discussion was had on that, and I think that that's again something that our staff really needs, because it means that if our zoning doesn't make any sense in a particular circumstance, we're going to have to move a tree over 2 inches. Not going to work. In order to make something work, the director of planning can actually make a decision on that. Doesn't have to actually go, put the applicant through the expense, the time, all the rest, to do something that should obviously be possible and permissible. This actually gives latitude for that sort of thing. And like I said, that along with the valid reasons, these are 2 of my favorite things, because it actually empowers staff, specifically our director of planning, to actually make adjustments when the rules are insufficient, as they are. That they're not, they should be getting a variance, but it really shouldn't be needed, because it's so common sense. So I do think that'll save applicants and staff a lot of time and us time too. Not worried about our time so much, I'm just saying, but I think everybody else will be really happy.
Okay, Councillor Lajeunesse.
Yeah, I agree with that. It allows staff to exercise common sense and innovation, which is something that I'm always in favor of.
These are minor in nature. But I would just at a later tape, like an example of where that last bullet actually comes into play. Because every example had referred to the previous first bullet. That's why I don't get why this is in there. It's not clear.
I can provide one right now, if you like.
Okay.
Yeah. Okay. So I think the example that Nancy used in her presentation was like a pie-shaped lot. So you could have lots, maybe panhandle lots or pie-shaped lots where, say for the panhandle, for example, the front lot boundary actually includes that, which is parallel at the throat, essentially, of the lot all the way through. So that would be considered a front lot line. And in some cases, a variance would be requested because the other panhandles within that lot, and you'll see this actually next council, would require a reduction to the front, which is 4.5 to 1.5. It acts like an interior, but without it being regulated as an interior, it would cause unreasonable lot size for home construction.
Okay, so how does that differ than the first bullet where it talks about the unusual parcel shape?
Yeah, I guess there's a bit of redundancy there. But
Okay, that's why I'm like,
Yeah.
okay, I get that because it was in the first bullet,
Okay.
but I don't get why it's separate. That's all. But that's a topographical feature. So I'm being difficult, but I don't, it's what I'm voting on something I don't fully. Okay, anyway, I'll stop. I'll call a question. All those in favor? That's carried unanimously. Okay, the next one is on the strata, the delegation of authority residential strata title conversion. That the authority to approve a straddle title conversion in accordance with the following subsections. In deciding whether to approve a strata title conversion, the Director of Planning and Development must consider the following guidelines. The priority of rental accommodation over privately owned housing in the area. Any proposals for the relocation of persons occupying a residential building. The life expectancy of the building. Projected major increases in maintenance costs due to the condition of the building and any other matters that in the opinion of the Director of Planning and Development are relevant.
So just some context here as well, if I may. So the current policy for residential strata conversion includes this language verbatim. The only shift that's occurring here is the delegation of authority, moving to the director from council.
Councillor Pearson.
I'm a little less comfortable with this one, particularly when it comes down to the small strata conversions, like the duplexes, like cutting the duplexes in half. This one just doesn't feel like it flows together with that consideration for me. The wording in there is, you know, it's geared towards what it looks like, several tenants in one building. We had a presentation recently of a strata conversion or an application for a strata conversion. If we start applying for this is one that I think that for me, the delegation of authority here would make more sense, or this would feels better to stay in the hands of council because we're not going to get a lot of these. In Sooke, we don't have a lot of potential buildings that are strata conversions anyways. It's the duplexes, and I think they have to be done on their own merit. That's just an opinion. So I'm not making the motion.
Councillor Beddoes.
Yeah, I agree. I think 6 years I've been here, we've had one. And that's not onerous for us to take that on. And again, because it depends on the neighborhood, it depends on a lot of things. I'd be comfortable leaving that with council.
Councillor St. Pierre. Microphone, no.
Okay, I'll move the motion.
Councillor St. Pierre is moving it.
Okay, I think that this is just an example of streamlining. We don't necessarily have a lot of them, and that's fine. But I think in terms of actually having a streamlined process, our time is not actually necessarily what we need to consider here. It's actually the time of the applicant and staff time. So in terms of actually speeding them on their way, this is one of the ways to do it. It's not something we have to deal with very often, but I guarantee that an applicant that's going through the process is going to be happy if they can get it done like 3 to 6 months sooner. And the staff can actually put their time towards things that are more useful. So I would suggest it's part of the suite of the whole thing. It just makes sense. Please. Yeah, I got you.
Councillor Pearson.
I think that, and I don't disagree with in the suite of things like streamlining the process, but when I start thinking about those individual applications and no change to base density, you're just taking a duplex and cutting it in half, and we're asking for road frontage improvements, et cetera, on duplexes in neighborhoods where these buildings are already existing. I think it bears a responsibility for a council discussion as opposed to it being delegated, because all of a sudden it's going to come to council anyways, because they're going to feel that, you know, where I'm not changing base density in this neighborhood and I have a legal duplex. Thank you.
Sure.
I think you're absolutely right, but you're also absolutely right. If we delegate the authority and there's an issue around something that's being asked for within the rules, you know, as has happened, and the applicant feels this is not actually something I should have to do, they're going to bring it to us anyway. So it's going to come forward anyway. And at that point, it's actually the people who never had a problem where it's all good. They're really benefiting from this change. And it doesn't really affect those people that, you know, would come forward to council anyway.
Okay, other comments? All right, seeing none. Call the question. All those in favor? Opposed? Oh, wow. Okay, we have an outcome here. So Bateman, Tate, Pearson and Beddoes are in opposition, so that one fails. And I believe that reaches the end of the. We would have phoned her. The end of our committee of the whole. So these items are going to flow to our next regular scheduled meeting, which is on May the 13th. So I'll look for a motion to adjourn today's committee. That's Counselor Bateman. All those in favor? And that's carried unanimously. Thank you. Thank you, staff, and thank you to our consulting team.